Yes.
Apropos, my lord, yesterday's Lord, regarding my lord, that second constitution bench, my lord, yesterday, my lords indicated, my lord, we have taken instructions. Lord, the position is this, my lord. In 2020, Lord, other honorable judges, my lord, may not be aware. My lord, yesterday, the discussion regarding next constitution bench under the IDA, and I was to respond. What is the position? Well, the position is in 2020, there is an industrial code which is passed by the Parliament. But since rules are in the process of being made, it is not yet notified. But there, the definition of industry is in conformity with Bengal water supply.
Oh,
Bangalore water supply laws. So, my lord, the suggestion subject to the approval of the honorable benches, my lord, if it can go, my lord, after vacation, but we can also take a call whether to amend the definition or what stand the government would like to take. That's otherwise, my lord, we are ready and we will.
We can then put it out. Then, because anyway we have now two days this week and 3 days next week.
Only 1 week, practically, my lord, 1 week. Because yesterday, tomorrow, your lordships have fixed some, my lord, the judges matter also, and this can't be over in a week. The industrial dispute matter can't be over.
We can keep it in July on the reopening. We'll notify the date.
Yes. My lord, kindly come to volume 2D, capital D, my lord, D for Delhi. Lord, my submissions on Article 39. But before that, my lord, I would wish, my lord, your lordships to see Article 37, which is not, my lord, of course, your lordships would be knowing about it, but it's not brought to your lordships' notice in this matter, my lords. That would show, my lord, the sanctity which the framers of the Constitution have attached to directive principles of state policy. 37, my lords. But last lines, my lord, are, in my respectful submission, yes, my lord, even lawmaking. No, not, my lord, just executive governance, even in lawmaking. Application of the principles contained in this part. The provisions contained in this part shall not be enforceable by any court, but the principles therein laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these principles to making laws. There is a constitutional obligation, so to say, on the legislature also to apply these principles. Now, my lord, kindly come to, my lord, my note, volume 2D. My lord, the width of Article 39, because, my lord, your lordships, obviously, my lord, would bear in mind the question, my lord, which is being, for which we are assisting your lordship is whether a private property would fall within 39 or not, my lord. In that context, my lord, this is my perception of Article 39. The ownership and control of material resources of the community are so distributed as best to subserve the common good. My lord, each word in my respectful submission, my lord, is, my lord, pregnant with meaning of making a welfare state. Lord, if I have to, my Lord, give one word for this entire article, it is to create a welfare state, my Lord. Now I would dissect, my Lord, why each word is used very carefully by the framers of the Constitution. But it says ownership and control of the material resources. My Lord, if the framers of the Constitution would have envisaged that the property owned by the government to be used for the purposes, my Lord, which are mentioned, then there was no occasion for them to say that ownership and control would be used. Ownership and control would necessarily mean that something which do not belong to the government, but in the larger interest of the common good, there can be a law passed
But these have to be resources of the community.
I'm coming to that, Manoj. The word used is not material resources of either the state or the government. It says resources of the community, which again leads to an indication that it includes both government property and other than government property.
Learned Solskjaer, you must have, since we are on 39B,
My lords.
and you are proposing to dissect the words there. Now, obviously, you are also going to look at, now when you say ownership, not with the government, it is obviously in the private sector,
Both.
right?
It can include both.
It can include both.
Both.
So ownership and control of material resources, as the Honorable Chief Justice has pointed out, and what is to subserve the common good.
I'm coming to that.
Right. This common good element is very important because
That's the, my lord, key word in the entire section.
that's right. So whether common good, of course, this is in the context of the provisions in the MADA Act. Whether
In general, we are, my lord.
Yeah, that's right. I mean, you are giving a broad interpretation.
Correct.
but the discussion also has to relate to what is contained in the Maharashtra Act
Yes.
pertaining to the properties.
Yes, my lord, but nobody touched, my lord, MADA Act from the point of view of its validity, etc. It was just by way of an example. But I am, my lord, broadly, irrespective of, my lord, MADA or any movable or immovable property, any property. Property can be, my lord, a private mine, for example. It is a material resource. It is a resource not belonging to the government because it's a private mine. But therefore, my lord, the key words are, it should be, if any law is made under Article 39B, it should be A, for distribution. B, it should be to subserve common good, not good of any particular section of the society. Therefore, I say common good is the key word, my lord, of this. That you take over some property for the purpose of, say, one section belonging to one race, one religion, one caste, one profession. That is not what is contemplated. It has to be a community property not belonging to the government. It is required for being distributed, and the ultimate goal has to be common good. And therefore, my lord, in one word, this, my lord, provides for an ideal definition of a welfare state. This is not distributive justice.
The question is whether ownership of the community is also equivalent to ownership of an individual, or ownership of a community also encompasses individual ownership of property. That is the question
My
now.
lord, that will have to be, my lord, so read. Otherwise, it
Whether a
loses.
community means an individual.
I would answer that question, my lord. It will have to be so read, depending upon the facts and circumstances. For example, my lord, in my house, uh, there is a rare mineral which is discovered. It's not a property of the community, it's a property of the individual. But then the key word would be material resources. If individual property has material resources which can be distributed and ultimately for common good of the citizens.
Therefore, actually, your example is very apposite, because what your example shows is that there may be instances where, in respect of private property, there is a community interest. Now, this is clearly a case of that nature. Namely, though the property is of a private individual, underlying that property, you have say uranium, or you have some very rare,
Yes,
rare resource, which is really a resource of the community. And therefore, there can't be a very strict dichotomy between private and public. At the same time, it is a little too extreme. The formulation by Justice Krishna is a little too extreme. What that formulation says is, since the community consists of individuals, and therefore every individual is a part of the community, if the material resources of the community would therefore mean also resources of the individual.
No, my lord, it will have
That may be a little extreme. I'll tell you also.
This would be an extreme, my lord.
It would be a little extreme. Also, we must now be cognizant of the fact that all these constitutional provisions are they have an evolution. We are now interpreting them not in the context of the India of 1950.
Nationalization to disinvestment. That's
Right.
the
Yes.
transition.
Therefore, we must adopt an interpretation which is in keeping with the changing nature of the times and the society which and at the same time, we must also have an enduring interpretation. So it may well be that certain resources which are vested in private individuals may still have some general bearing of public interest or community welfare, the welfare of the broader community, which requires regulation by the state.
Yes, but for example, land, road, making of a road. Lord, land is a material resource when when the function you are discharging is making of a road. Lord, some land is coming in between. Lord, it is for common good, for distribution, and it is a material resource, maybe belonging to not the entire community, but an individual. So, Lord, therefore, the law will be in tune with if each and every word is existing, my lord, simultaneously. And I would, my lord, add one more thing.
Also,
Ownership.
39B postulates that there has to be a diversification of ownership and control. Why does it say ownership and control of the material resources of the community is distributed? So this is speaking about the need for diversification of ownership and control to protect the common good. That is, you don't want a concentration of economic resources in the hands of...
If they are material resources.
They are material resources of the community.
Well, it's not, my lord, for example, my lord, a rustic...
Dispersal would maybe or that's what distribution means.
Yes, my lord. Because, my lord, for example, a rustic way of looking at it is that you total up the wealth of the entire nation, divide it by the people whom you feel that needs to be distributed, and whatever is the figure, distribute it. My lord, that's not, my lord, what 39 means. My lord, that would be a lack of understanding of governance as well as economics.
We can't attribute to Article 39B and C, at least in today's times, a sort of a definition which gives, expression to an unbridled agenda of communism or socialism.
Absolutely.
But that is not our economy or our constitution today. We still protect private property. We still protect the right to carry on business. We still want, as part of, say, a national agenda, I won't say the government's agenda, because this is across...
No, it is an agenda of the nation, whichever is the government is.
From 1990, and so it was irrespective of party lines and government. We have now expressly adopted a policy of encouraging investment by the private sector, realizing that until then it was all right that the government was involved in very high levels of investment in the industry. But now, truly, if we have to have a productive enterprise, you have to encourage private investment.
Yes.
And therefore, our interpretation must also be, nuanced. to take care of what India is today and what India is moving towards tomorrow.
Lord, investment in the private sector is now boosting common good. Then, my lord, what was envisaged in, my lord, 49, 47?
For instance, in 1950, nobody envisaged that you would have electricity distribution by private companies on
Private
such a
companies.
scale. Now you have that today.
Yes, ma'am.
They couldn't have envisaged that, well, the private sector will be building up infrastructure like roads, like ports.
Lord, one of the judgments, very illuminating judgment.
Airports.
Airport, my lord, for example, about airports, my lord, some of the activities are, my lord, privatized. Not the essential activities like customs, security, etc. But some of the activities are privatized.
We may not have a very strict dichotomy that, well, something which is totally privately owned can never be a material resource of the community. That would be a very extreme statement.
Yes.
But it would be an equally extreme statement to postulate that everything which is private is a material resource of the community, which the Attorney General argued. That may not be a
Your argument is actually going contrary to what the Attorney General
You are
was.
more-
My lord, I
more
would, my
nuanced
lord,
and more in the middle. You're
a
taking
little
middle
new
path.
nuance, my lord. I would not, my lord, argue contrary to him, but my nuance is different, my lord. Your lordship knows, my lord, what I am trying to say, my lord. And my lord, so far as, my lord, the view expressed by my lord Justice my lord Krishna Iyer is concerned, my lord, it deserves respect. But with respect, my lord, I would personally and on behalf of the government, my lord, would not subscribe to that view at this stage of the
Exactly.
country's economic
Should
development.
we be sending a message across? Because what we write will send a message of what India is and what
Yes.
India aspires to be.
Yes.
So any interpretation which we look, we don't want to dilute the constitutional or social significance of 39B and C. It's there for us. I mean, it's given to us. At the same time, we should not be sending a message by interpreting 39B in such a wide sense. There is no protection of private rights in the society
Yes.
at all. How will we attract private investment if we say that there is no protection afforded?
It's counterproductive. That interpretation may not be in national interest, my lord, but
But
we
we'll
have
not
to-
go as far as to say that anything which is private can never be a material resource of the
No,
country.
that's not,
again,
that's another
that
extreme.
cannot be. Yes.
That's another extreme.
Yes.
For example, my lord, in Mada, my lord, if the government sees that there are, say, 500 people staying in 500 dwelling units, which are in a dilapidated condition, they may have their own justifications for staying, and there is a justification because roof over the head is a justification. My lord, the owner, who is the landlord, he will not spend because he has a justification that I am getting less money. The government is not concerned with their ownership dispute or tenancy dispute. The government would merely say that we are concerned with your life. We provide for a mechanism under which we will evict you. Somebody would pay you the rent for the interregnum till your houses are newly constructed. You fight it out whether you are a tenant, you are a deemed tenant, you have to be evicted, etc. That's not the contractual relationship we are concerned with. So that would be material resources of the community requires proper distribution for common good. So, my lord, therefore I say that each word is pregnant with meaning, and that is how, my lord, your lordships may consider taking a path which is neither on this extreme nor on this extreme.
More balanced
Balance.
perspective on.
Well, that's the
See, for
respect.
example, an individual owner, in this case, an owner of a building which is in a dilapidated condition,
So that we will answer it separately. We will answer it separately.
and this, it all depends to what extent.
My lord, my lord, MADA Act and the validity of individual acts, my lord, there are separate answers. There are separate answers to that. But the government would not enter into that area of tenancy my lord, owner-tenant relationship.
Right to develop.
That's not, my lord, the issue. Please, for the time being, Lord, that we have, my lord, our justifications for the purpose of protecting the validity. That was just taken up as an example. Therefore, Lord, I am not going much into it. I am more on a wider canvas for the nation, for the national economy, and the economic growth at which the nation is progressing at this stage. What should be the meaning of
So
this?
how would you formulate it? So we can just take it down, it'll just give some clarity to us. We
Yes,
can
my
just
lord,
take a
my
moment
formulation
so
is
that
this,
You
my
can
lord.
reflect on it and tell us.
My lord,
How would you formulate
Yes,
it? We
my
can
lord.
just take it.
the 39 small b is a measure for developing
A little slow.
a welfare state with the ultimate goal of common good. I'm sorry, madam.
Goal of protecting the common good, we'll say.
Common good, the ultimate goal of protecting the common good
Or achieving the common
or
good.
achieving, my lord, I'm sorry, madam. When material resources of the community needs legislative intervention of either taking over ownership, and this is my nuance, my lord, and oblique or control. The Constitution says and, but I'm saying it can be read even as or. Lord, sometimes, my lord, why I say or? Lord, suppose there is a private mine. The government may not take over the
How would we
ownership.
but you have to complete the sentence.
I'm sorry.
When material resources of the community need legislative intervention or taking over ownership or control,
To achieve, my lord, that common good of the
I'll tell you how you began.
control of the material resources. I'm
Article
sorry.
39B is a measure for developing a welfare state with the ultimate goal of achieving the common good. Then is it comma when material resources of the community need legislative intervention of taking over ownership or control?
Of ownership or and oblique or
And or
control
control.
For taking.
of material resources
Need
of
legislative intervention of taking over ownership or control
and oblique or, my lord,
and or.
because Constitution says and or is, my lord, my interpretation of material resources of the community
For distribution.
For distribution.
Yes.
Just going back to this, can we, I mean, we're not putting you into a corner. I mean, it's a thinking aloud. Can we say that you don't accept either of the two extreme positions? I mean, as a government, one extreme position is that every element of private property is a material resources of the community. That's one. Just think over it. Second, that no private property can be a material resource of the community. There are two extreme positions.
My lord, I
One,
think I my
right?
lord, respectfully agree.
Isn't it? Because
I
there are
respect.
two extreme positions that no private property can be a material resource of the
That
community.
is one extreme.
And second, that every private property is a material resource
No,
of the
no.
community. So we don't,
The
we
test,
eschew both the.
the test
Can we
that-
take it down? Can we take it down? Because
Yes, yes,
it'll give us some clarity later on.
yes, my lord. My lord, the test, if challenged, my lord,
You'll have to formulate it,
yes.
because then
Look.
it will depend upon the context.
Exactly.
See, this is, this is everything.
My lord,
This will be maybe the crux of the matter, because then everything perhaps may depend upon the context, upon the situation. As the chief rightly said, the interpretation of the 50s and 60s may not be relevant now.
What?
Constitution, therefore we say it is a
Context.
living document,
It has to be seen
changes its meaning.
in that way. You have to tell us, and you'll have to also tell us what do you understand, how should we understand community?
Yes.
So that
My lord, may
also
I do one thing, my lord, instead of, my lord, your lordships, my lord, being troubled with writing down, well, I'll prepare one paragraph and give it to, that this is how my stand is, but I, my lord, agree with so far whatever, my lord, the Chief Justice has said, and my lord Justice Dhulia has said. that it depends upon the context. Depends upon, my lord, what is community. Contextually, it can even be an individual, if the material resources are community-based.
No, I'll give you an example. For example, let us say there is a community, a tribal community, right? They know where a particular herb or something is to be located. Well, now that belongs not to an individual, maybe lying in an individual's farm or agriculture field, but it will belong to the entire community, right?
Correct?
But the community, will it be only that tribal community or people of that area or the entire country? That you will have to tell us, because when 39B was being debated, one of the bill was to make it community of, instead of, it should be citizens instead of.
My lord, K.T. Shah, my lord, Mr.
Something. So it was not done. So deliberately this word community was chosen.
To make it wider.
But how wider? When wider and when narrower?
Instead of, my lord, my responding immediately, my lord, can I, at the end of it, give, my lord, my version of it? But so far I am, my lord, completely, Lord, bow down and in agreement with what my lord, the Chief Justice has formulated.
I was just, as you were having this conversation, I was listening to Brother Dulia and you, and I made a note on the context. Now, in the context, we can identify three factors at least. I mean, this I've just done it offhand. One, what is the nature of the resource and its characteristics? Airwaves. Very different from a private property of a different nature. So what is the nature, the spectrum? The nature of the resource and its characteristics. Two, the impact of the resource on the general well-being of the community or the common good. Third, the consequence of the concentration of ownership and control on the common good.
So that may perhaps not be.
Some resources you may not want them to be.
Yes, like uranium. I understand.
Right.
I bow down. That it cannot be with one individual.
Scarcity of the resource.
Yes. Your lordships, if that my lord is added, my lord, then scarcity or any peculiar significance of that resource is not left.
These are by no means exhaustive factors. They
Yes.
again have to be evaluated from case to case, from context to context.
Yes. And the class should be identifiable class. The community doesn't mean the entire country. That whatever is there, you take it and distribute it. That's not, my lord, a juvenile way in which the constitutional framers have, my lord, understood.
So the thrust of 38 and 39 is that wealth of the nation or the material resources, as they say, should not be concentrated in a few hands.
If it is
That's the-
required for for common good,
Huh.
and not that it should not be, the government is enabled through parliamentary legislation to intervene and, my lord, take either ownership or control. So there is no prohibition that it cannot be. But if other conditions are fulfilled, then the legislature can intervene.
The word is shall, not 39, 38.
Yeah.
The state shall strive to do so.
Yes, while making the law. Yes, my lord. Therefore, I am saying, your lordships are right, that enabling provision is to make the law where this will have to be borne in mind. My lord, I'll give one
Yes.
paragraph, my lord.
So now what next you want to
No,
formulate?
next, my lord. I'm skipping what is not relevant. My lord, I have given the definitions of control, ownership, etc. But just only one line. My lord, the Constitution says ownership and control. But I would respectfully urge that the words are disjunctive. It can be or also. For example, my lord, why I say so? My lord?
To read ownership and control as ownership or control.
And or both. I'll give the example. my lord. For example, in a private mine, there is a huge tract of land, my lord, belonging to me. And there is some, my lord, a mineral discovered there. The government may not be interested in taking over the ownership of the land. Ownership may retain with me. They will take control over the land. So how much mineral will be excavated? What will be the royalty to be paid? That's
And ownership actually.
Therefore, my lord, I'm saying that depending upon the context, it can be ownership and control. It can also be ownership or control, depending upon, my lord, the context. Your lordships can skip the definitions. If they are, my lord, quoted only for the purpose of,
So solicitor, where are you on the note? Which page?
my lord, up to page 8, my lord, there are definitions quoted. This is only for ready reference. I'm not going to read it. Please come to page 9, my lord. My lord, drafting history.
That 9-page note, no?
No, my lord,
No,
I'm
sorry,
sorry.
16-page note.
My lord, volume 2D.
2D.
2D,
Okay, okay.
my lord,
I thought
I'm
2B.
sorry, my
I
lord,
thought you said 2B. All right.
But I said D for Delhi at the beginning.
Yes, I took it as D. Yes.
Yes. Lord, kindly directly come to page 9. PDF 11.
So 2B was solicitor's 16-page note. I said solicitor has been uncharacteristic in this case. Now I realize it's 74 pages.
My lord, why I am little longer? Well, there are two reasons. A, I quote the relevant para so that
You
your
have to
lordship
keep
may
on
not have
coming here
to
and there.
shuffle through, my lord, various volumes. And second, my lord, the reason Winston Churchill gave, that I'm writing you a long letter because I don't have time to write a short letter. So because you really need precise understanding of the subject to write something crisp.
Churchill or Shaw?
Pardon?
Bernard Shaw, actually. It was George Bernard Shaw.
Yes, my lord.
Isn't it? That's from my recollection. I mean, I may be wrong.
My lord, my lord, there are three individuals. Lord, there are three individuals.
Brother
To whom-
Dulia has made a comment. I think that's relevant.
To be short.
Yeah,
My lord, if it is not a privilege,
No, no, since you are such a
Writing is difficult.
Urdu adab and Urdu literature, somebody said that I had to write a very small letter had to be written.
हिंदी में बोलिए.
एक छोटा सा खत लिखना था, इसलिए ज्यादा टाइम लगे. छोटा सा लिखना.
yes. And तो नहीं ना मुख्तसर सी बात है.
हाँ, मुख्तसर हो जाइए.
Yes, there is a ghazal, मुख्तसर सी बात है, तुमसे प्यार है. But that's the short thing I want to say. I don't need an essay for that. Mukhtasar means, my lord, short.
It takes more effort to be precise.
That's exactly what, my lord, Churchill or Bernard Shaw or whoever. My lord, these are the three individuals to whom most of the things are attributed. Churchill, Bernard Shaw, and Oscar Wilde. And Mark Twain. Yes, my lord, he is my nephew, Mark Twain. And the same thing happens with Mirza Ghalib. Unfortunately, my lord, completely footpath level शायरी is attributed to him. Last में वो मरीज लिख देते हैं, गालिब लिख देते हैं. Lord, para 9. Lord, what was in the mind of the framers of the Constitution? Well, I'll not read the entire, but Lord, please see the first. Lord, this is the discussion by one Mr. S. Nagappa. Sir, this clause is the only clause where the poor man, the common man, can find some hope for the future. Clause 2 and 3 are identified for the benefit of poor men. No doubt it would have been better if this clause had been drafted in more unequivocal terms instead of in this ambiguous language. As a layman, as a common man, I can see more ray of hope for the future in these clauses. It is the aim of the honorable members who have assembled here to socialize as early as possible. As long as these clauses stand, there is no possibility of capitalism thriving in India. I am very much thankful to the drafting committee and to the president of it, in particular, for having brought in these clauses. And my only grievance is that they have not been drafted in more unequivocal language. Sir, so this is important, my lord. This is now changed. Sir, the slogans today are municipalize utilities and nationalize industries and means of production. And unless and until these things are done, there is no hope for the common man. My lord, now the economical infrastructure and the concepts, my lord, have changed from municipalization, that is nationalization, to, my lord, free trade, etc. Privatization.
Investment.
And that's what Dr. Ambedkar very prophetically said, that it is purposefully not made unequivocal because there can be different ways of dealing with an economic scenario. Then at the foot of that page, para 10, further, Mr. K.T. Shah had proposed the following clauses to substitute Article 39B and C. In that the ownership, control and management of natural resources of the country in the shape of mines, mineral wealth, forests, rivers, flowing waters, as well as in the shape of seas along the coast of the country shall be vested in and belong to the country collectively and shall be exploited and developed on behalf of the community by the state as represented by the central or provincial governments. 2 is relevant, that there shall be no private monopolies in any form of production of material wealth, social service, or public utilities, nor shall there be any concentration of means of production and distribution in private hands, and state shall adopt every means to prevent such concentration or accumulation. This was the theory or the thought in those days, my lord. Now, please see, my lord, Dr. Ambedkar's reply, my lord, on 15th November 48. The second reason, my lord, this is Dr. Ambedkar, I quote, the second reason is that the amendment is purely superfluous. My honorable friend, Professor Shah, does not seem to have taken into account the fact that apart from the fundamental rights which we have embodied in the Constitution, we have also introduced other sections which deal with directive principles of state policy. If my honorable friend were to read the articles contained in part 4, he will find that both the legislature as well as the executive have been placed by this Constitution under certain definitive obligations as to form of their policy. Now to read only Article 31, that is draft article now 39. Your lordships can, my lord, on the side mark that, which deals with this matter. It says, then they have quoted, my lord, the article, draft article, which is substantially on the same line. Then I again read, my lord, Dr. Ambedkar.
Yes.
Lord, your lordships can now come to, my lord, page 13, the highlighted part. Lord, the question is, it starts with, my lord, Dr. Ambedkar. My lord, rest may not assist your lordships on the question being considered. Therefore, I am skipping, but I have put it there, my lord, for completion. The question is, have we got any fixed idea as to how we should bring about economic democracy? There are various ways in which people believe that economic democracy can be brought about. There are those who believe in individualism as the best form of economic democracy. There are those who believe in having a socialistic state as the best form of economic democracy. There are those who believe in communistic idea as the most perfect form of economic democracy. Now, having regard to the fact that there are various ways by which economic democracy may be brought about, we have deliberately introduced in the language that we have used in the directive principle something which is not fixed or rigid, leaving it, my lord, for the next generations, as world economy develops, as Indian economic growth develops, to take a call which economic model the country would choose. Well, this is very foresight and my lord, almost prophetic, which is not fixed or rigid. We have left enough room for the people of different ways of thinking with regard to the reaching of the ideal of economic democracy to strive in their own way to persuade the electorate that it is the best way of reaching economic democracy, the fullest opportunity to act in the way in which they want to act. Sir, that is the reason why the language of articles in part 4 is left in the manner in which the drafting committee thought it best to leave. It is no use giving a fixed, rigid form to something which is not rigid, which is fundamentally changing and must, having regard to the circumstances and the times, keep on changing. It is therefore no use saying that the directive principles have no value. In my judgment, the directive principles have a great value, for they lay down that our ideal is economic democracy. Then highlighted part. To lay down that our ideal is economic democracy, and also to prescribe that every government, whatever it is in power, shall strive to bring about economic democracy. Much of the misunderstanding under which most members are laboring will disappear. Then, my lord, Shibban Lal Saxena. This is a clause, my lord, he again deals with draft clause 31, the present 39. This is a clause which is very fundamental in our constitution. The character of the amendment suggested also shows that it goes to the very root of the whole constitution. My sympathies are undoubtedly with the amendments of Professor Shah, who has moved 2 amendments, which really suggest that in his clause, we should lay down that the system of our state shall be socialist. In an amendment to the preamble, I have suggested that the word socialist should be added before the word union. I personally feel that particular amendments which he has moved are very important, and I would urge my friend Dr. Ambedkar at least to incorporate the spirit of those amendments somewhere in the Constitution. Part 2 of Article 31 says ownership and control of the material resources are the same thing. Then Malodi further adds, this is maybe important, assist your lordships. Now this enunciation, ownership and control of material resources of the community to be distributed so as to subserve the common good is a very wide enunciation of a most important principle. The enunciation is so general that any system of economy can be based upon it. Upon it can be based a system of socialist economy, where all resources of the country belong to the state and are to be used for the well-being of the community as a whole. But a majority in the next parliament can also come forward and say that the New Deal evolved by Roosevelt is the best system and it should be adopted. This clause leave it open to any future parliament to evolve the best plan of their choice.
So what was good for the country in the 50s up to 1991 may not be good after 1991.
Exactly, they wanted to keep it open.
Evolving concept, and the clock comes back. We don't know when, after some time, privatization becomes so stressful that we go back to what was good in the 1950s in the decades to come. We don't know.
Therefore, it is left to Parliament.
It's all evolving.
Yes. And my lord, this New Deal by Roosevelt, my lord, is that capitalist
is in soon after independence, they said the new dams, Hirakud Dam, Bakra Nangal, they are the new temples of India.
Yes, Bakra Nangal was the first.
Because that is what was necessary.
Yes, absolutely.
But now, after all that development, now the focus is on individual or private development. Country has developed to some extent. Now the private development or the individual development, therefore liberalization, privatization, globalization, investment.
Keeping pace with the international economic development, etc.
LPG.
Lord, just Lord, subject to correction, Lord, out of interest, Lord, this New Deal by Roosevelt.
This is the Second World War.
The Second
After
World War.
29 to 33, not the Second World War, sorry. 29 to 33 when there was a great, the Great Depression.
And my lord, those, my lord, 4 horsemen and 3 musketeers, my lord, that's how the Supreme Court used to be consisting of 7 honorable judges and 4 judges always in majority, my lord, did not permit Roosevelt to carry out any of these.
Because, you know,
Great
what happened was all the social welfare legislation like minimum wages, maximum hours of work, they were struck down by the Supreme Court of the UK or the US on the ground that they interfered with the private freedom of contract, or therefore the due process clause.
Yes.
And the due process clause was applied in a substantive sense, so as to allow the court to oversee what policy Parliament was, the legislature, Congress was following, the houses of Parliament were following. And the Justice Holmes was the dissenter.
Yes.
That the Constitution does not permit the court to adopt a policy which a majority of the judges think is proper. Eventually, the New Deal legislation was upheld by one judge of the Supreme Court. There was a court packing agenda. They
Yes.
thought that they will alter the
That
course
was
of
the
history
word used, court
Backing
packing.
of the court.
by introducing a few more judges there.
10 more judges.
But then what happened ultimately was one judge switched his vote. And that vote which was switched is called in history the switch in time that saved the 9.
Saves the 9, my lord. And my lord, there are some interesting material on that.
And then they started upholding, all the social welfare
It
legislation.
was 3 versus 3. One judge was, my lord, my lord, not clear, and it is, my lord, written somewhere. They used to travel. They used to ensure that they travel in the same car and constantly being persuaded, and he remained with the 4. Anyway, my lord, I'll just, my lord, go further. My lord, now please see the last word of Dr. Ambedkar at page. Can we skip? The last concluding remarks of Dr. Ambedkar at page 50. Lord, it starts at page 14, but highlighted part at page 15. I think the language that has been used in the draft, a much more extensive language, which also includes the particular propositions which have been moved by Professor Shah, and I therefore do not see the necessity for substituting these limited particular clauses for the clauses which have been drafted in general language deliberately for a set of purpose. My lord, and the purpose is, Lord, this is, my lord, the emphasis I would very respectfully give. The object and purpose was that it is open for each legislature, depending upon the period of time they are making the economic policies, can have freedom to lay down economic legislations. My lord, complete freedom in joints is given to the Parliament. That's the intention.
Yeah.
So, my lord, ultimately, it is left to the Parliament. Therefore, a little not vague, but elastic, I would, my lord, put it that way, which can take into consideration the circumstances, factors, global factors, local factors, etc. Now, my lord, I am on page 16. Your lordships need not turn to. What I've said is this. The question, my lords, are deciding is whether a private property can be included under Article 39. What I've said is that when 39 was there, right to property was a fundamental right under Article 31.
Yes.
19(1)(f), my lord, I'm sorry.
Which page is this in your paper? Page?
16. 16. PDF 16.
Yes.
So, my lord, 39B and Article 19(1)(f), that is right to hold and dispose of property, coexisted, meaning thereby 39 always intended even private property. And its deletion now as a fundamental right and it going at as Article 300A further strengthens, Lord, that submission that 39B encompasses not just government property. Otherwise, for constitution makers, Lord, there was no reason to say that all property owned and controlled by the government shall be used for general good. Lord, simple. Lord, now, Lord, I have given the statement of objection reasons of 45th Constitution Amendment. I'll skip that, my lords. That may not be relevant, my lord. While going through, my lord, for writing judgment, if your lordship needs, my lord, I have kept everything, my lord, so that your lordships have on one click, my lord, get it. Lord, now please come to, please come to, my lord, page 25. My lord, I have given, again, my lord, for your lordship's assistance. I'm not going to read them, but if your lordships would wish to go through it or, my lord, record it, my lord, in para 24 at page 25, there is one annexure A, where, my lord, I have analyzed the provisions of other constitutions on this aspect. And that is at annexure A, my lord. There is no point reading them. Lord, your lordships can mark its PDF page 72.
Taken from.
Please come to page 30. 30. Lord, para 39, my lord, if your lordships can. So this is what, my lord, I have already, my lord, paraphrased my submission, but this is another paraphrasing. India is a social democracy that aligns closely with the principles of a social welfare state. Social and economic justice is not to be understood in crude terms of distributive justice aimed at a wholesale allocation of the material resources of the community to the people at large in one go. On the contrary, a welfare state means a rationally tailored policy intervention, that is legislative intervention, in furtherance of common good, which may or may not involve compulsory acquisition, ownership and or control of private property. The effectuation of the same is to be carried out in a manner conducive to the common good, thereby achieving socio-economic justice. My lord, I have cited D.S. Nakara, but my lord, your lordships may consider, my lord, for the time being, my lord, not, my lord, read that. Please come to, my lord, page 35. My lord, your lordships are aware, my lord, like which, my lord, we assisted your lordships on the ground of another article where you have to give a declaration that this act is enacted in pursuance to so and so. The same is with 39. The act stipulates, my lord, that we are exercising, the parliament is exercising powers under 39B B or C as the case may be. My lord, I have just, my lord, given a table of several legislations where the Parliament has used and mentioned 39B. And my lord, please see the fourth column, material resource, my lord, which is sought to be regulated or distributed, my lord, under 39B. I'm not reading it. I'll just read, my lord, what are the material resources for which. My lord, my lord, I must add one thing. My lord, this declaration, the way in which, my lord, your lordships have seen, my lord, in other cases, my lord, of alcohol, industries, etc., is not mandatory in case of Article 39B. But even if an enactment is not mentioning 39B, the government can defend it on the ground that I seek protection of 39B and therefore 31C. Yes, my lord,
It doesn't say industry, the control of which is declared by
is
Parliament.
declared by because the Constitution requires a declaration. Here, the Constitution doesn't require the declaration. Lord, liquefied petroleum gas, crude oil, railway wagons and other goods essential to the need of railways. Then, my lord, 5 components of rolling stock like vacuum brake equipments, ejectors, steam brake valves, etc., etc. Some pharmaceuticals and chemicals, tractors, coke oven plants. Lord, some of them are repealed, some of them are in force, but that's not relevant. I'm just giving an illustration that these are the material resources for which the Parliament did, my lord, take into account and mention 39B. Anglo-French Textile Limited, employing a large labor force. My lord, only one company was taken over, which is still, my lord, in force. That is Anglo-French Textile Limited, acquisition and transfer of textile undertaking. Then handloom and weaving factory.
But where you write the material resources Anglo-French textiles. I wonder what is Anglo-French textiles. Anyway, that's.
It's a limited company, my lord, but
I thought I can say something here.
land, right to use water, Mysore Palace.
For example, a simple thing is the public distribution, where the farmers have to give levy sugar. The farmers have to part with some paddy to the state so that that is taken.
Distributed equally.
Public distribution under
Public
the
distribution, PDS.
provincial.
Yes, sir.
See, that is an example, clear, stark example, so close to the people.
I think the
Rationing of food grains.
learned attorney possibly, my lord, wants to say something. If
No, I was only trying to say about the Anglo-French textiles.
What is that?
I appeared in that matter way back in 1984. And that was a textile mill which is lying closed in Pondicherry for about 3 years. After this honorable court intervened, then the government set up a Pondicherry Textile Corporation. That's how it was taken over. And it was a private industry.
Oh. All right. Yes, Mr. Valentine.
Lord, then please come to, my lord. I have given 23 examples. This may not be exhaustive. We have tried our best to be, my lord, as exhaustive as possible. There may be some my lord, legislations left, but public transport system, etc., etc. Lord, now kindly come to, my lord, PDF 38, para 47. Where, my lord, this honorable bench, my lord, permitted placing of reliance under 39B while defending a particular challenge to an enactment. That is Bhim Singh ji, my lord, her ladyship, my lord, mentioned.
Case where there is a change in the mindset. 1976 Urban Land Ceiling Act came, and in 1999 it was repealed. That is during the times of 1999 post-liberalization.
Correct.
So 1976 and 1999, that is a stark example of how there is a evolving economic democracy
Yes.
in the country.
Depending upon several internal and external factors. And when I say external means global market, internal factor means my lord, the production decreasing or increasing, the demand being less or more, etc., etc.
All right.
Lord, I'll just read the highlighted part of Bhim Singh ji, where urban land selling laws were under challenge. The whole story, my lord, just above, my lord, just before the highlighted part, the whole story of the legislation, the long gestation of pre-legislative consideration, the brooding presence of Article 39B and C, and the emphasis in Section 23(4) on common good as the guiding factor for distribution point to public purpose, national development, and social justice as the cornerstone of the policy of distribution, it is not and never can be compulsory taking from some private owners to favor by transfer other private owners. Lord, thereafter, my lord, this is all, my lord, last line, last passage, my lord, at page 39. I have already indicated that the postulate underlying the directive principles of Article 39B is that diffusion of ownership and control of material resources of the community is always in public interest, and therefore the state is directed to ensure such distribution equitable thereof as best to subserve the common good, but the priority is prescribed in subsection 1 and 4 of section 23 in regard to distribution of material resources produce contrary results as or results in the opposite direction inasmuch as private purposes receive precedence over common good. My lord, that is more on the act, my lord. Then, my lord, there is one, my lord, this judgment is, my lord, very Tinsukia electricity, where electricity under 39B was taken under the control of the government. Come to justice. Lord, there are other judgments where 39B is considered, my lord, for the purpose of testing the validity of a particular legislation, my lord. Now your lordships can consider, my lord, directly coming to 48. My lord, I have given all those judgments where 39B is considered, my lord, but broadly, the view, my lord, which your lordships have taken is this, my lord, that ultimately it must evolve. It has to be left to the parliament, because the parliament is the best judge to decide under present circumstances how the economic growth will take place, whether a particular mode or a particular my lord, format is a better suited format or not. Lord, page 48, Lord, Coal India, my lord, it is judgment, my lord, by 3 honorable judges, my lord, authored by Justice K.M. Joseph, a very recent judgment, of which, my lord, her ladyship Justice Nagaratna was also, my lord, a part of the bench, where Coal Mines Nationalization Act was considered. Lord, the issue was whether this act would, the Competition Act would apply to Coal India or not in view of Coal India, Coal Mines Nationalization Act. Well, please see, my lord, the underlined portion. Well, this is per Justice Joseph, my lord.
Which para you are reading?
Lord, para 97, page 48,
97.
para 57 of my note,
97 of the judgment.
97 of the judgment.
Para 57 of your note.
Yes, my lord. Recently, my lord, it starts with that. Recently, the lordship gets me. My lord, Justice Roy gets me.
Yes, yes.
Recently, a 3-judge bench in Coal India Limited versus CCI, that is Competition Commission of India, in the context of applicability of Competition Act, to Coal India, which was created under the Coal Mines Nationalization Act, it was hailed as under. The appellants are government companies. They were brought into being in the context of Section 3 and 5 of Nationalization Act. Undoubtedly, they were created to take the place of central government in the matter of supervising, control, and managing the affairs of the mines. Still further, and more importantly, the Nationalization Act itself was intended to achieve the goals in Article 39B of the Constitution. This means that the Nationalization Act contemplated coal to be a material resource and it was to be distributed so as to subserve common good. The exclusive right in regard to the mines, as also the power to manage and supervise the mines, was vested with the first appellant company and its subsidiaries. The ambit of the power is unquestionably wide. We proceed on the basis that the appellants cannot be oblivious to its duty to bear in mind the sublime goal in directive principles, that is distribution, so as to subserve the common good. Lord, please come to, my Lord, next, my Lord, page 49, para 100 of the judgment. Does your Lord, am I with your Lordship? The expression common good in Article 39B is a Benthamite sense involves achieving the highest good of the maximum number of people. The meaning of the words common good may depend upon the times, the felt necessities, the direction that the nation wishes to take in future, the socio-economic condition of the different classes, the legal and fundamental rights, and also the directive principles themselves. As far as the time dictated content of common good goes, it simply means that economics itself not being bound in chains, but it is a dynamic concept. This, my Lord, evolution will be, my Lord, with the Parliament. Then, my Lord, the attainment of common good would be dependent on the appreciation and understanding of a generation as to how economic common good is best achieved. The debate between advantages and disadvantages of pursuing the policy of the state intervention in economic policy, which emasculates private enterprise and competition, has almost reached its end. The advantages of a fearlessly competitive economy have been realized by the nation. There is a backdrop to it. In the year 1991, as Ladyship was saying, the nation was, in a manner of speaking, compelled to revisit its economic policy, having regard to the precarious condition of its foreign exchange reserves. The Permit Raj, which involved acute regulation of economic activity by the state with all its attendant evils, cried out for reforms. A slew of highly liberal reforms in 91 set the stage of the nation to make paradigm shift. As discussed in Raghavan Committee report, things moved further in the direction of attaining faster economic growth. The Act is a measure which is intended to achieve the same. The role which was envisaged for the public sector company could not permit them to outlive their utility or abuse their unique position. Disinvestment done in a proper manner was perceived as a solution. However, sans disinvestment, state monopolies, public sector companies, and government companies were expected to imbibe the new economic philosophy. The novel idea which permeates the Act would stand frustrated. In fact, if state monopolies, government companies, and public sector units are left free to contravene the law, your Lordships cannot skip. Kindly come to 120. We agree with the appellants, and as held by this court in state of Karnataka versus Raghunath Reddy, Lord, the judgment which is placed, Ranganath Reddy, my Lord, which is placed for your Lordship's consideration, that distribution is a word of wide meaning and it is covered by Article 39B of the Constitution. It must be remembered that court had occasion to hold so by way of dealing with the argument that nationalization did not have a nexus with the word distribution. Now, my lords, may kindly come to page 51. Lord, the argument was, I'll just paraphrase my submission, my lord. The argument of the other side was, that was more in the context of MAHDA, that preservation of buildings or preservation of natural resources can never be a part of Article 39B. My lord, which, my lord, I have dealt with saying
Yes.
that intergenerational equity is a concept accepted by our jurisprudence. We preserve many things for the next generation. That is, my lord, what we call intergenerational equity. Please see, my lord, page 51, para 59.
That phrase has been used in this judgment? What
No.
you're saying?
No, not in this judgment. But there are several judgments where intergenerational equity, word, my lord, I'll place it for your lordship's consideration. But that's an accepted position under Indian jurisprudence, that this generation protects and preserves like, as a trust for the next generation. Yes. Forest, land, natural resources, minerals, etc., etc. And also intergenerational equity is used. Now, I'll place, my lord, those judgments while highlighting that part. 60. The purpose behind Article 39B, my lord, I'm reading 60, is to secure the ownership and control of a resource in order to distribute it in a manner which results in common good. The argument of the petitioner, therefore, is that preservation of a resource does not amount to common good. Apart from the fact that the said argument is unsustainable owing to the natural wide meaning of the term common good, preservation of any resource is often required in order to further the common good for the people at large and the nation as a whole. For example, the new entrenched principle of intergenerational equity propounded by this honorable court in the context of natural resources provides that resources need to be judicially used in order to ensure that future generations are able to enjoy the fruits of the same. Intergenerational equity requires, in a welfare society and a society based on egalitarian principles, preserving resources, even though they are privately owned, for the common good of the future generations. The constitutional principle of egalitarianism requires that intergenerational equity is adhered to. A balance is required to be struck. Within 63. Intergenerational equity thus requires that present generation utilizes, Lord, that's more repetition, I can skip that one. Lord, I have cited, my lord, two judgments on intergenerational equity. One is state of Himachal Pradesh versus Ganesh Wood Products, and another, my lord, as my learned friend, Lord, Mr. Dwivedi, the younger Dwivedi pointed out, my lord, Eklavya, para 65, T.N. Godavarman. Mr. Eklavya, he is also younger Dwivedi, my lord, but Lord, then consistent precedents on the issue without any conflict. Lord, I will not read it. Your lordships were, Lord, taken through all the judgments where the definition or the interpretation of 39B, which we seek to give respectfully, has been accepted, my lord, be it Ranganatha Reddy or, my lord, Abu Kavur Bhai, etc., etc. Or, my lord, my last point now.
Yes.
Lord, I have already, my lord, respectfully said that the views of Justice Krishna Iyer may perhaps not be relevant, my lord, in the present context. I would put it that way, my lord, and I very respectfully, while respecting the judgment and the view, Lord, respectfully seek to disagree.
View or some of it?
The sum of them, my lord, it's no, not entirely. I have
It
too
will be
small
contrary
to
to your argument.
disagree with Justice Krishna Iyer in the entire.
I hate Sangaratari.
But it was otherwise also contextual. It was in the context of the private property involved in that case, but the discussion became very wide and over-encompassing, my lord, which may...
He said that we are not to be construed as having accepted this line of
Correct.
this line of
Correct.
analysis.
And that was in a concurring judgment.
Concurring.
All that was said.
Yes. Lord, page 62. Lord, and this is my last submission on 39B. Lord, my respectful submission is that Mafatlal Industries is not an arbiter. And my Lord, I raised that point very seriously. Lord, this is a judgment delivered by 9 honorable judges.
Are you touching?
Lord, page 62, PDF 62. And I have quoted the relevant paragraphs.
Mafatlal, there is only mention in one paragraph.
72.
That's it.
My 72, my Lord.
Your 72. In Mafatlal also it is in one paragraph.
No, Lord, that's what is not pointed out. But that's what I want to point out. And my Lord, my respectful submission at the cost of repetition, it is not an arbiter. It is a ratio decidendi. My Lord, I would urge your lordships to bear 3 factors in mind when a judgment can be said to be arbiter. A, whether the question decided arose for consideration. B, whether arguments were advanced by both the sides. And C, whether the court dealt with cursorily as a passing remark or while dealing with a specific submission made by the counsel. Lord, here, not only the lead judgment, even concurring and dissenting judgment is also, my Lord, answering this question. Something which is not, my Lord, brought to your lordship's notice. A specific argument was raised by Mr. Parasaran. And from the reading, your lordships, my Lord, in my respectful submission will find that in fact court wanted it to become a ratio decidendi. Lord, your lordships have page 62.
Yes.
My para 72 and
Yes.
judgment para 84. My Lord, kindly allow me to read this one because I want to show point was specifically raised. In this connection, Sri K. Parasaran has rightly emphasized the distinction between the constitutional values obtaining in countries like United States of America, Canada, and Australia, or for that matter, United Kingdom, and the values obtaining under our constitution. This discussion, we may reiterate, is also relevant on the nature of the constitutional right to refund or restitution, as it is called. That was the question, my Lord, in Mafatlal, flowing from Article 265, referred to in para 71 to 73. Unlike the economically neutral, if not pro-capitalist, constitutions governing those countries, the Indian Constitution has set before itself the goal of justice, social, economic, and political, a total restructuring of our society. The goal being what is set out in Part 4 of the Constitution, and in particular in Article 38 and 39. Indeed, the aforesaid words in the preamble constitute the motto of our Constitution, if we can call it one. Article 38 enjoins upon the state to strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, and political shall inform all the institutions of the national life. Article 39 lays down the principles of policy to be followed by the state. It says that the state shall in particular direct its policy towards securing, B, that the ownership and control of the material resources of the community are so distributed as best to subserve the common good, and C, that the operation of the economic system does not result in concentration of wealth and means of production to the common detriment. refunding the duty paid by a manufacturer or SSE in situations where he himself has not suffered any loss or prejudice is no economic justice. It is very negation of economic justice. By doing so, the state would be conferring an unearned and unjustifiable windfall upon the manufacturing community, thereby contributing to concentration of wealth in a small class of persons which may not be consistent with the common good. The preamble and the aforesaid articles do demand that where a duty cannot be refunded to the real person who have borne the burden for one or the other reason, it is but appropriate that the said amounts are retained by the state for being used for public good. Indeed, even in an economically neutral constitution like the United States of America, such a course has been adopted by the state and upheld by the courts. It would be rather curious, nay, ridiculous, if such a course were held to be bad under our constitution, which speaks of economic and distributive justice, opposes concentration of wealth in few hands, and when a 42nd Amendment describe our republic as a socialist republic. Lord, please come to, my Lord, at the foot, para 86, that the material resources of the community. Now, my Lord, kindly see, they discuss it specifically. 39B is discussed, not as a passing remark. In the first para, the learned judges say this is relevant even for deciding the question of refund. Then they say in para 86 that the material resources of the community are not confined to public resources, but include all resources, natural and man-made, public and privately owned, is repeatedly affirmed by this court. Sri Ranganatha Reddy, etc., etc., etc. Now, my Lord, may kindly see para 73. Justice Paripurnan's concurring opinion. Lord, an obiter dicta, in my respectful submission, would be in one judgment. If it is also discussed, a point is also discussed and deliberated and adjudicated upon, even in the concurring judgment, Lord, it can never be an obiter dicta. Obiter dicta is just something said in passing. The question never arose, arguments not made, court never intended to decide that point, and as a passing said something. Here, my Lord, after reading the majority, I am, my Lord, reading the concurring view of Justice Paripurna. Lord, please see at the foot of page 64. Lord, just, my Lord, for 10, 5, 7 line, my Lord, from the underlined portion, Sri K. Parasaran, my Lord, your Lordship gets, my Lord. My Lord, Justice Paripurnan also is pleased to note the contention of Mr. Parasaran. Sri K. Parasaran brought to our notice the following portion of the preamble and Article 39B and C of the Constitution to contend that Article 265 of the Constitution cannot be construed in a vacuum or isolation, but should be construed in light of the basic principles contained in other parts of the Constitution.
We got the point that you are saying that it was also dealt with by Justice Paripurnan. What happened was, the question was whether if a tax is struck down or if the levy has been held to be illegal, whether there should be a refund. The court said that, look, the manufacturers have not, they've passed on the burden.
Yes,
They are pertinent, and therefore it will result in unjust enrichment. And therefore, on the one hand, if you say that, well, the manufacturers will be entitled to a refund, all these resources will go into the hands of the manufacturers and promote a concentration of wealth. On the other hand, these resources could be used by the state for the purpose of the common good. And therefore, they said Article 39.
Material resources for the community, stressing it from 39B. Now, my Lord, what is not quoted, but I must bring to your Lordship's notice, there is a minority view in Mafatlal judgment, my Lord. Please have a look at, my Lord, volume.
Just give us that, we'll just make a note of it and
Yes,
take your word for it.
My Lord, volume 5.
Whose minority view is that?
Justice Sen, my Lord.
All right. So volume 5 page.
Volume 5, relevant is, my Lord, at page 2914, paragraph 161.
That's all right. We'll take it that.
There also,
Minority also
contention noted and dealt. So, my Lord, my respectful submission is, Lord, there is no need, my Lord, for my Lord, the bench, my Lord, sitting in the combination of 9 honorable judges, my Lord, to revisit that point unless it is, my lord, referred to a still larger bench. My lord, last,
Nothing to do with 39B.
my lord, now, my lord, I will come to my lord, this is the submission on 39B. Now, my lord, I would wish to assist your lordships on the question of 31C, my lord, according to them, that goes. It's a dead letter. My lord, since that was raised, my lord, subsequently, my note is, my lord, subsequent, my lord, that is 2L. Two capital L.
Capital L.
L for London. Just for ease of reference.
It's like the vacation is in your mind, solicitor.
Why, Manoj? No. Your lordships are right, my lord. I could have thought of some, my lord, state, my lord, in India.
L for Lakshadweep.
Yes, my lord, nothing, my lord, in the contextually, well, L for Lakshadweep, not for London. Lord, for the ease of my lord reference, I have taken the liberty of giving different color to 31C. Lord, first part, which is blue in color, and second part, which is red in color. Correct, Manoj? Please see the red part, because this is what is
Red was struck down in Keshwan.
in Keshwan. That's all, my lord. My lord, one more thing. My lord, I can place it on record, and I do wish to place it on record. Lord, so far as validity of 31C, except the red part is concerned, in Keshwan and Bharti, all 8 honorable judges unequivocally upholds it with separate reasons. And I would, my lord, each para I would quote and place it for your lordship's consideration. My lord, the general discussion, my lord, which happened, this is not my argument, my lord, just by way of, my lord, reference, that in Keshwan and Bharti judgment, who decides what and what is ultimately ratio for what proposition, my lord, is not a criticism or a discussion qua 31C. 31C, the bench is very clear. 8 honorable judges unequivocally, with reasons, uphold the validity.
Yes.
Now, your lordships, my lord, kindly see. It is, my lord, now amended, para 4. Just, my lord, since few days have passed, my lord, just to refresh your lordship's memory, and there is
all or any principles enshrined in part 4.
Yes, my lord, that is para 4. But, my lord, I would like to again read, my lord, para 4, my lord. 42nd Amendment, see, this is section 4 of the Constitution Amendment Act. Correct, my lord? Please bear that in mind, because my submission is going to be that this amending section has gone. 31C was never under challenge. And if the view propounded by them is accepted by the court, what will be the devastating consequence? I have given illustrations. Lord, for example, tomorrow, one word from the preamble is deleted by way of a constitutional amendment. That constitutional amendment is challenged, and your lordship set aside that amendment that you could not have deleted. Economic justice, for example. Would the entire preamble go? That's the argument, my lord. It sounds absurd, but it is that absurd, and I'll show that.
Your argument for language is now meaningless.
It becomes completely meaningless.
Yes.
And I have quoted that language, that now if they are right, how 31C would read.
Meaningless totally.
It becomes meaningless.
No, section 4, the amendment of Constitutional Amendment Act, section 4. That section 4 is inserted into the main section, Article 31C. It is inserted,
Substituted.
yes. So it becomes part of Article 31C. It does not have an independent existence.
Correct.
Maybe by a Constitutional Amendment Act, but ultimately it goes into the main Article
Correct,
31C.
So now what was included now no longer exists.
Yes.
And what was there in law has to exist. My lord, that is my respectful submission. Now, my lords may kindly see, Lord, this was challenged, and Lord, first,
So according to you, once section 4, the 42nd Amendment is struck down, that necessarily results in the restoration of the position as it existed on the date of the adoption of that provision.
and one more
That's your
thing,
contention.
my lord, why? To buttress my submission. Lord Justice, my Lord Justice Y.V. Chandrachud upheld the validity of 31C. My Lord Justice Y.V. Chandrachud authored the judgment of Vaman Rao, which challenged the original 31C. But simultaneously, the bench presided by my Lord Justice Chandrachud, who also happened to be authoring judgment in Minerva, I'll show that, was considering post-amendment 31C. So there were two matters simultaneously going on. Vaman Rao, 31C as upheld by by Keshwanand Bharti. Second, Minerva Mills, 31C as amended by 42nd Amendment. Both judgments delivered by my Lord Justice Y.V. Chandrachud. And therefore, my Lord, I'll show there is a clear intention of the court. Court is conscious that this is what will be the effect of our judgment, that what was upheld by Keshwanand Bharti now stands revived.
Clear.
Have they said so?
His lordship, pardon? Yes, my lord. My lord, if your lordships are,
You concluded because your second point, no?
this is my second.
So if you can just take us briefly through
Lord,
it.
I'll just
Get
take
the
a
other
lordship
side.
through it,
Then
my
Mr. Dwivedi will take it.
Without, my lord, reading.
So according to you, Vaman Rao was dealing with the unamended 30.
Unamended
That's
31.
your contention.
There is no dispute on that. Minerva was dealing with section 4 of amended, section 4 as amended by 42nd Amendment. Both decided by same learned Honorable Chief Justice, my lord, who was the only factor common with Keshwanand Bharti also.
But did Vaman Rao deal with the unamended section 31C in respect of a period after
The amendment.
the striking down of the amended 31C?
Yes, my lord.
Or was it dealing with a period prior thereto?
No, after. And therefore it says that what will...
Prior.
No. Kindly have a look at, my lord, kindly have a look at it.
Anyway, but just think, bear it in mind. We don't, you can go in your own way and then
Judgment came
come back to
subsequent.
Lord, the writ petition was 77. But please come to, my lord, page 6, para 6, my lord, page 3.
your formulation, Mr. Solicitor, on this.
My lord, my formulation is, my lord, can I show and formulate?
Sure.
Can
You
I
can
show
just
and
quickly,
formulate?
yeah, that's right.
My lord, page 6, my lord, para 6, page 3.
Page 6.
Para 6, my lord, page 3, para 6.
Yeah.
My lord, again, I'm sorry, my lord, but the same learned Chief Justice,
Yeah.
Lord Justice Y.V. Chandrachud. Why I, my lord, refer to the name, the purpose is that his lordship was aware that I have dealt with one 31C challenge at 30 as a combination of 13 judges. Vaman Rao is 5 judges, unamended. And now I have also heard Minerva Mills, which is post-amendment. And therefore, my lord, in that context, please read his lordship's word. My lord, para 4. In these proceedings, the main challenge now is to the constitutionality of Article 31A, 31B and unamended Article 31C of the Constitution. Now, my lord, kindly see last line on page 3. We are concerned with Article 31C as it stood originally but of course without the concluding part struck down in Keshwanand Bharti. So his lordships were dealing with the first part because second part was struck down by in Keshwanand Bharti. Now, my lord, para 7. Again, my lord, in Vaman Rao, my lord, the learned Chief Justice says, 52, that leaves for consideration the challenge to the constitutional validity of unamended Article 31C. As we have stated at the beginning of this judgment, Article 31C was introduced by Constitution 25th Amendment. Initially, it sought to give protection to those laws. Your lordship can skip.
This is again Vaman Rao, no? This quotation.
This is Vaman Rao. Then 53. Mr. M.N. Phadke, who led the argument on behalf of the petitioners, built a formidable attack against the vires of Article 31C. But with respect to the learned counsel, the effort is fruitless because the question as regards the validity of Article 31C is no longer res integra. The opening clause of Article 31C.
What was the law in question in Vaman Rao? That was the Maharashtra Agricultural Ceilings Act?
Yes,
Maharashtra.
agricultural tenancy or see.
There were 32, Article 32 petitions, my lord.
It was the agricultural holding.
Agricultural Land, within brackets, Sealing and Holdings Act, 1961. But his lordship decided.
Had to be decided on the basis of the unamended Article 31.
Correct. Therefore.
Because on the date when that law was enacted, unamended Article 31, bench did was, they tested the validity of the law with reference to unamended Article 31C. It was not a post-Minerva Mills legislation.
It was not. It was not. It was pre-Minerva Mills.
Come to the same conclusion, but we must have conceptual clarity that Vaman Rao was basically dealing with and clearly an unamended Article 31C.
It says so.
So Vaman Rao may not have a bearing on the residue of Article 31C which remains post the decision in Minerva. Vaman Rao may not really be conclusive. We will have to address it as a matter of first principle.
Lord, it would have a bearing for the simple reason that both Vaman Rao and Minerva Mills were heard together and decided by the same learned judge.
That militates against your submission because it's very clear that in Vaman Rao, they were not considering the impact of what will remain after 31C as amended by the 42nd Amendment is struck down. They were not considering that at all. As to whether there would be a revival, whether that would, as a matter of first principle, we may still come to that conclusion, but Vaman Rao does not give us a conclusive guidance on that.
Correct, but
It doesn't relate to that
It
period.
doesn't relate to the period at all, which we are now dealing with here.
But kindly, my lord, come to the last part, para 54, because his lordship also deals with 31C on a different ground and upholds it. I understand what is falling from your lordship, my lord, the Chief Justice.
I think the substantive answer which you have to the argument of the other side should be something like this. The original provision of 31C, which granted protection or immunity to laws against a challenge, so long as that law implements 39B and C, that original provision was upheld in Keshwanand Bharati, except for giving finality to the declaration.
Judicial review was over.
Judicial review was saved. Now, the widening of the ambit takes place in the 42nd Amendment. When Parliament widened the ambit, the idea was never to replace what was the original content of 31C with a completely new provision, but to expand the ambit to include 31, 39B and C plus all the other provisions. What was held to be objectionable in Minerva Mills was not the original ambit of 31C, but the extension, because they could not have said that the original 31C was invalid for the reason that they were bound by Keshwanand Bharti, which they also express. So essentially, according to you, what was struck down was this unlimited power which was given, expansion of 31C to include not merely 39B and C, but the entirety of Part 4 of the Constitution, because the court said then every law which can be sustained on the ground that it implements some provision of the directive principles or the other.
Correct.
So when Minerva Mills strikes down Section 4, you must read the intent of Parliament and the intent of the court. The intent of the court is not to strike down the entirety of 31C.
It was not under challenge.
But the
Only
intent
Section
was
4 was under
expansion. Now, therefore, to hold, according to you, that look, even the original 31C is therefore completely obliterated by virtue of the substitution by Section 4, would be in that sense a very formalistic reading of the Constitution.
Another point, my lord,
We are on, is there a more, other than saying it's a formalistic reading of the Constitution, is there a constitutional concept which we can, is there at a conceptual level, can we not?
may I, my lord, assist your lordship on that?
Doctrine of revival applies.
It would not be necessary, my lord. There would not be revival necessary at all. I'll tell your lordship why. Your lordships are aware of the Blackstone doctrine, which is accepted in India by Golaknath downwards. But Blackstone doctrine says that your lordships do not declare the law, your lordships merely validate or invalidate the law. Lord, kindly give me a minute more, my lord, to formulate my submission. Lord, suppose today Parliament amends the law by amending Act number so and so. Section 2 of the amending act amends the law or the Constitution. My principle governing this, both, my lord, would be same. After 2 years, your lordships were to strike it down. That no, this is unconstitutional. Right? I'll read, my lord, that passage, my lord, passage from Golaknath judgment, where Blackstone doctrine, my lord, is followed. What your lordships would be doing is, your lordships would be declaring it to be invalid from the date of its inception. It never was born. When your lordship says in Minerva that Section 4 of the amending act is unconstitutional, that substitution goes, meaning thereby the original 31C was always there. That is your declaration, your lordship's declaration. That is, my lord, Blackstone doctrine and accepted in India. It would remain on the statute book.
That's his argument. That what would remain on the statute book? Mr. Andarjana's argument is
31C as it.
No, his argument is what remains on the statute book is 31C as amended. But it is held to be inoperable or unenforceable.
If your lordship sees, my lord, Blackstone.
If it remains on the statute book, according to him, if it remains on the statute book but is rendered unenforceable, then you cannot have another provision to the contrary on the statute book, which your argument would entail. That's the
If your lordships are, my lord, not going into this question, my lord, but there is one more point.
The better way of perhaps looking at it is this: that what was the parliamentary intent in its constituent capacity? The parliamentary intent was not to delete Article 39B and C from the ambit of the amended 31C. The object was to continue with 39B and
In
C
an expanded.
and then expand the ambit, right? The original provision was upheld in Keshwan Bharti. Now, the purpose of Parliament in the 42nd Amendment not being to delete the reference to 39B and C, but to expand the ambit of Article 31C, the declaration of unconstitutionality of Section 4
She put it on the group.
reach out to 39B and C, but those principles of Part 4 other than 39.
39. Yes.
Right? And therefore, when Section 30, we may then be able to skirt this whole issue of revival and other things
Yes.
by looking at this particular factual context, this particular constitutional context, because you have to look at that constitutional concept, constitutional concept and perspective.
But when the
This is not capable of easy resolution. That's why we are 9 of us looking at it here.
Yes.
If it was so simple, we wouldn't be here assembling in
My lord, there is, my lord, a judgment.
since
Solicitor, Mr.
Madam.
Andarshana's argument was that the power to repeal a provision is a power which is exclusively entrusted to the legislature. It is not a power which is conferred to the court. And the court cannot, therefore, when it strikes down, do something which is really a power of the legislature. The legislature can always say, all right, instead of all or any of the principles, we substituted with the word Articles 39B and C. That's the power of the legislature. You as a court don't have the power to do that. You can only declare that this is null and void and therefore of no enforceability whatsoever. That is the argument. How would you deal with that
My
argument?
lord, would it apply? My lord, I'm posing a question to myself. Yeah, what? I think we go to
I think
Formulate it. What is your point? So that then we'll
Yes,
wrap up.
Milord,
We'll
before
we'd like
that-
to hear a little more submissions on this. We've got your point, but how would you then put it together in?
Yeah. Milord, before that, before I formulate, can I only show one paragraph in Minerva? Milord, can I show one? I'm sorry. Lord, Lord, in Minerva Mills,
But in Norman law also they could.
Lord, in Minerva Mills, please see, my Lord, page 7, only read portion
Of your note?
of my note. Page 7, the I'll be as fast as I can, my Lord. Only read portion your Lordship has, my Lord?
Yes.
My Lord, while comparing the old and the amended, the same learned judge who decided all three, who was a part of all three and, my Lord, author of the two, the question for consideration in light of this position is whether Section 4 of the 42nd Amendment has brought about a result which is basically and fundamentally different from the one arising under the unamended article. If the amendment does not bring about any such result, its validity shall have to be upheld for the same reasons for which the validity of unamended article was upheld. And thereafter, my Lord, the learned judge, my Lord, is pleased to say that no, it gives a different result. My Lord, therefore, my formulation is this. My Lord, the principles of interpretation in case of a statute and the Constitution would be different.
Yes.
Second, the Parliament, while amending 39B, 13(1)(c), never intended to delete or obliterate 39B and C.
Yes.
Therefore, when
Third.
it merely expanded the protection under Article 39 B and C to entire Part 4. what was found fault with was the expansion and not Article 39B and C.
Found fault with in Minerva.
And therefore, the moment Minerva judgment comes, the expansion goes. And not the original 31C. Fifth, my lord. Sixth, my lord. The learned judge, my lord, who decided Vaman Rao, and who possibly, my lord, was also in the process of dictating or deciding Minerva, makes a positive declaration, my lord, which is not under challenge.
I think in one part of your statement, you are wrong. What I understand is that those days, the judges used to write by hand instead of giving dictation. In fact, copious pages were written so far as the judgments were prepared. So remarkable fortitude and effort that was taken.
Possibly, therefore, the judgments were also not very long and precise. Lord, please come to that declaration, para 9,
That we have seen
para
at
16,
the end of Minerva.
para 16.
In other words, you're saying Vaman Rao, which came later, has to be read alongside with Minerva Mills.
Because it happens to be decided by the same bench, well, only by even bench were,
There is a judicial, what you say, a statement made.
declaration made. It says, my lord, the declaration says in Minerva Mills that 31C, as upheld in Keshwanand Bharati, stands and only the amended part goes. It could not have been more elaborate or clear or unambiguous than this.
And because it has been upheld, Kanan Bharti.
It
Yes.
could not have been, my lord. Can never be. I'm obliged, my lord. That's going to be the submission. Lord, Lord, in a statute, there is a possibility of a void being created. But in constitution, there cannot be any constitutional void unless the court is dealing with validity of a constitutional provision which is declared unconstitutional. Lord, there is 31C is not under challenge in Minerva. Well, let us be very clear. Only section 4 of the amending act was challenged.
Right. And that's
Lord,
it, Mr. Now.
Only 5 minutes, my lord. And my lord, there is one judgment. I'll not read, my lord.
Which one is that?
Lord, that is on what happens when Lord, there are several legislative devices for the purpose of amendment. It can be by addition, deletion, substitution. What happens when the legislature chooses the design of substitution? And the Supreme Court has said, my lord, at page 10, para 23, this is my lord last judgment, I'll cite. What happens to substitute? I'll not, my lord, read. Your lordships may, my lord, read it, but it's very, my lord, illustrative and, my lord, it would assist your lordships that if it is substituted, and substitution is held invalid, the original remains. Examples on the well, last 5 minutes, well, give me last 5 minutes. Well, please come to page 14. Well, if your lordship takes the view which the other side is arguing, Lord, page 14. Lord, what will be the anomalous situation in a constitution, which is the document of governance of the nation? Lord, I have given some examples. For example, Lord, I have what we have done. The cases where constitutional amendment came by way of substitution. By way of substitution. Suppose that substitution is challenged and that substitution is upheld. Lord, what will be the struck down? What will be the anomalous situation? Please come to page 14. Lord, amendment in the preamble came by 42nd amendment by way of a substitution. Suppose that would have been struck down, the entire preamble goes by their logic, if their logic is true.
Substituted sovereign democratic republic with sovereign socialist secular democracy.
Substitute, they added.
But the amending act, no, Lord, amending act says substituted. Same language as for section 4. It is substituted, madams.
Substituted the word. They didn't say add socialist secular after sovereign and before democratic.
No,
They substituted.
Page 3966, it's on record.
No, we got it here.
Yes, volume 4, 3966.
The footnote in Mr. Shankarnaran's.
Yeah, yes. So the entire preamble goes by their logic. Now, my lord,
No,
amendment.
that is
not
not
the
their,
entire
that is
preamble.
not the import of their argument.
No, but that line goes. That
Everything goes in.
that is.
Everything goes.
Then your lordships are right.
Everything goes.
Literally everything goes, my lord. If their argument is accepted. My lord, I'm sorry, my lord, for giving this illustration. My lord, giving this illustration, the salaries of judges are also by way of amendment by substitution. There cannot be a constitutional vacuum. There can be a statutory vacuum. That's the contention.
The word.
I mean, in another way, sorry.
Earlier it was sovereign democratic republic. Now socialist and secular were added between sovereign and democratic.
Substitute. So the amending act uses.
But we are taking out this word and we are putting this. And it's 42nd amendment.
Correct, my lord, but I am on substitution, my lord, that if it is substituted part goes. Suppose your lordships were to accept the challenge to those new additions, then only substituted part goes, the entire part doesn't go.
Why it is second part directly affects us because that deals with our salaries.
Well, therefore I say kindly pardon me for this example, but salaries are always, my lord, amended by way of substitution. So there would be a vacuum, my lord. My lord, there can be a statutory vacuum. There cannot be a constitutional vacuum. No, that's the respectful
But
submission.
please rest assured, if you increase the salary, we will not strike it down.
No.
And it cannot be decreased.
No, we'll.
And it cannot be decreased. Service condition.
No, that's all. And 4 and 2 are perimateria. And now we're only last line, para 20. Please see page 20. How section 31C would look like or would exist if their argument is right. Para page 20. Saving of laws, Your Lordship gets
Those all or any of the principles will go completely. It will.
notwithstanding anything contained in so and so, no law giving effect to the policy of the state towards securing blank, blank, blank shall be deemed to be void.
No, according to Mr. Andarina, those words will still remain on the statute book, but they will be unenforceable. They don't go. That's the argument.
How do we reconcile, my lord, a preamble and large number of substitutions? Well, there are some inclusions also. By way of amendment, something is included. But we have examined the substitutions. And please examine, my lord, if that, my lord, kindly, my lord, your lordships are aware, my lord, when privy purses were taken away. Privy purses were taken away by way of a constitutional amendment. Because Constitution promised that we would be giving this privy purses. My lord, they failed. But suppose they would have succeeded. Kindly, my lord, examine. This is a, my lord, glaring. I'm sorry, my lord. My lord, this is my last example, but a glaring example. After, my lord.
By and large, we got the-
Only last example, which I feel, my lord, is a glaring. This argument would put the court in a little helpless position. That's what I want to show. That's what I want to show. Therefore, this interpretation should be avoided. My lord, in original constitution, there was a my lord, article which gave certain assurances to the princely states by way of princely purses. My lord, the government of the day decided that we should do away with princely purses. Princely purses. Privy purses. Lord, that is section, Article 360, whatever. Lord, that deletion was challenged. Correct? Deletion was challenged. Ultimately, the challenge failed. But suppose the challenge would have been allowed by your lordships.
Was allowed, you know that. Because it was by an order.
By order, it was
They said
executed.
that these rulers will be derecognized. That's why they said you can't do it. Then
But
Parliament
you can't do it
upheld.
You can't do it in an executive action.
Well, just
Raghunath
election.
Rao, Raghunath
Just the
Rao.
election
But
was-
thereafter, the court said first that you can't do it by an executive order, you have to have a constitutional amendment. Now, please see, my lord, suppose that challenge would have been successful. The article goes, your lordships cannot enact the law. That letter would remain that they would get privy purses. If somebody were to come before your lordship will have to say, if they are right, that sorry, we have struck down the deletion, but we can't do anything unless the parliament re-enacts. But that cannot be the intention.
Thank
So
you.
Mr. Salve wanted to say something because he appeared in both Vaman Rao and
Mr.
Minerva
Salvi?
Mills, if your lordships can.
Yes. My lord, I just want 10 minutes, my lord, and I'll finish at lunch. By the
Before my learned friend starts, just one small interjection, Claude will permit me.
Mr. Attorney will come back to you after lunch because Mr. Salvi only wants 10 minutes. So that.
No, fair enough. I thought after lunch I may have some. I just want to say I prepared a note.
All right.
Yeah, I'm not going to ask you to read that note. That note is on first principles and entirely addressing this question of revival. So I just want to say you lot kindly read that. Probably some light may be available in that note.
Just ask your junior to give us the volume number for your notes. So
I
we
will
can-
do that. I'll do that. I'll do that.
Yes, line, my lord. The judgment in Minerva and Vaman Rao was delivered on the same day.
9th May 80. 9th May 80.
No, my lord, I
Two.
just wanted to add two things.
Yes, Mr. Arya.
My lord, the fallacy lies in
Operative
applying-
order.
Operative portion.
Operative.
Yes, yes, operative one. My lord, the fallacy lies in applying rules of statutory interpretation to reading judgments of the court, molding relief in constitutional matters. My lord, Article 368's construction that there is a limit on the power of Parliament to amend the Constitution is one of the most perhaps dramatic developments of constitutional law jurisprudence in the world. How that power is exercised and what is the consequence of that power, only your lordships can say. So reading rules of substitution, interpretation, repeal are, my lord, completely misplaced. And my respectful submission is a declaration by the court doesn't repeal a law. A declaration by the court results in the law being stillborn. The declaration given in paragraph 75 of Minerva Mills relates to section 4, not article 31. This is very important. And Article 4 said,
Section 4.
Section 4 said, in Article 31C, for the following words, substitute the following words. Minerva Mills said, if we allow this substitution, then 31C, which was upheld in Keswanan, is radically changed and the changed 31C, this change in 31C violates the basic structure because it dismantles the trilogy of rights, 14, 19, and 21.
That's correct.
And the words in paragraph 75, your lordship has read it over and over again, quoting the operative decretal order, which had first been pronounced, was section 4 is beyond the amending power of Parliament and is void. Let's stop there. The since doesn't matter. If section 4 is void, it is as though it was never enacted. Where is the question, my lord, of saying parts of section 4 It doesn't say that part of section 4. Your lordship's declaration, decretal declaration is section 4 of the Constitution Amendment Act is beyond amending power of Parliament and is void. If 4 is void, and that's your lordship's declaration, then you scrub out 4 from the statute book. 4 was stillborn. It never breathed life. Whereas the question of parts of 31C going away and parts of 31C remaining. The whole of 4 was void. That's the short answer to this, Malad. And it is a nostalgic moment for me. It's a nostalgic moment for me, Malad. That's why when the Solicitor General asked me to assist, I was trying to hold fort, Malad, as Solicitor General for the state of Maharashtra, when the redoubtable Mr. Nariman argued this point first before 5 judges. And we were first called upon to say, is there a 31C? Then, my lord, we argued 31C. Then he argued the main point about the challenge. And immediately I was called upon. I said, I rely on 31B and 39B and C. When, if I remember correctly, sitting on the right side, Mr. Justice M.B. Shah said, oh, but this resources means government's resources, not private resources. So I cited Sanjeev Kok. That's how that issue got referred to 7. Before 7, a bench headed by Mr. Justice Barucha. I cited Mafatlal. That's how it got referred to 9. The issue was always about 39B and C. If this point had to succeed, Malad, the second issue didn't arise. If this point had succeeded, there was no question of reference. 5 judges would have said there is no 39B and C on the statute book. We have already held it violates Article 14. End of the road. So, my lord, I submit this point it's a non-point with great respect. One cannot superimpose rules you apply for statutory interpretation and working the General Clauses Act to Article 368 and the power of this court to determine the contours of 368. But what your lordships do is, when your lordships say it is beyond amending power, suppose, my lord, this bill had been passed by Parliament ordinary present and voting, what would have been the result? Your lordship would have said nothing has been done. If a state assembly passed a law saying we repeal 39B and C, would your lordship take cognizance of it? You won't. So, my lord, when your lordship says it violates 368, don't take cognizance of this section 4. Life goes on. That's the result, my lord. That's, I would submit, has to be the approach in these matters.
Thank you, Mr. Zare. Thank you.
Deeply obliged.
Thank you, sir. We'll come back after lunch and hear Mr. Dwivedi now.
Oh, my lord, what? Yes, my lord.
And of course, this is in lighter vein. You are giving voicing concern about substitution of the preamble and whether preamble, if the argument of the other side is to be accepted, whether the preamble would exist. In that case, we'll have a constitution without the preamble, meaning thereby a constitution which will simply amble.
Your lordship. And if preamble goes, my lord, nothing remains. In fact, my lord, as my lord Justice Dhulia said, then
Yes, Mr. Reddy.
So I would like to deal with Article 39B first. And noting the concern of the court, that the two extremes have to be.
Yes.
The question referred is not whether private property is covered or not. The answer could have been simply that yes, it is covered. But the question then arises is to what extent? Is it entirely within the ambit of 39B? If not, then what is the principle? What is the basis of drawing a line, keeping out some kind of private property outside 39B? Or should it be left entirely to the Parliament to draw the line on an empirical basis? Because all economic policy is an exercise in empiricism. It's not permanent, and it assumes different shapes and forms at different times. With march of history, many things which were unknown have become private property. Even ideas have become, once patented, they are property. So all kinds of goods and movable, immovable, all are falling within the domain of property. So is it feasible for the court to enter into this and draw a line? Something which was sought to be done in the Constituent Assembly, as has already been shown to your lordship, that Mr. K.T. Shah
Yes.
and Mr. Shibban Saxena, they wanted, in one sense, to confine it to natural resources, rivers, etc., and to some monopolies, private monopolies. So one thing is there from the debate history emerging, that private property was never considered by anybody to be outside. The entire speech of Mr. K.T. Shah and Shibban Saxena, who sought amendment, is also directed at private monopolies. The private profit making. And the response of Dr. Ambedkar was that everything which you want to do can be done within 39B as drafted, namely as it exists today. And we have deliberately, consciously used wide words, general words, so as not to limit. So something which the framers, the Constituent Assembly, did not think it appropriate to draw a line to limit and leave it flexible. Should it be done today, my lords? Because any line drawn cribs the power of the Parliament to deal with a particular situation which we do not know would or will not emerge in the future. Your Lordship's interpretation of Article 39B is not for today. If it is not limited by the past, it surely should not be limited by today. As my Lord Justice Nagaratna was pleased to observe, my Lord, that supposing in future the Parliament finds that this privatization exercises which are being done become stressful, harmful, and obstructive, if I may go to this extent, to the further march. So everything, Lord, in economics, Lord, a time comes when it becomes, a time is when it is helping the further growth, a time comes when the very same thing becomes obstructive. Then you have to change courses. We may go back, you may go forward, further forward. all sorts of experimentation should be allowed to the Parliament. And the court should then see, Lord, as and when the exercise is done by the Parliament, and then see what has been done, Lord, is it going too far into the private domain? Surely no Parliament will be interested in taking away the spectacles and the watch of the individuals. But that kind of private property is not a resource. I bought a spectacle and I don't earn from it. It's, in Hindi, we call it Samudayic Sansadhan. So it's the resource of the community. I must be able, if I have one house, a hutment, so no Parliament is going after the hutment of that Dalit Mulad who is living in the village. First of all, there will be the democratic check. If they do that, surely they don't want to last. But quite apart from that, it doesn't mean to say that there should not be a judicial check if possible. But that's not a resource of the community. It's not a resource at all. So there is a private property construct wherein will fall a large number of ownership of individuals, which is not actually a resource at all. It's for personal use. Somebody's cycle, somebody's scooter or motorcycle in today's modern world, they're all, or refrigerator, these are all modern needs of the person. That doesn't result in any further source of income or profiteering to the individual. So what was being targeted was the private monopolies, the private profiteering, the concentration of wealth, as they say in 39C. So these are the guiding things, Lords. Some learned counsels said on the other side that 38 is separate, 39B is separate, 39C is separate. It's not like that. Even the preamble projects itself into the directive principles. 38 projects itself into 39B and C. They don't stand in isolated glory. They strengthen each other. The purpose is identical and same, and that is economic justice, as Dr. Ambedkar put it. Justice, social, economic, and political. So this is surely not political, this is in the economic sphere. Economic justice, therefore, he spoke of in the context of 39B.
Yes.
So idea is to equalize, which means there are those people at that time in 1950s, and even subsequently, there will be people who are owning a huge wealth. And all we know, Lord, and we read every day that inequality is growing. So with all this privatization, the growth of GDP, we have side by side. So along with multi-stories and big mansions, etc., we find the slums. So this is a product of privatization. Privatization is at the same time resulting, and we are watching it. And the whole world today, Lord, wants, the entire country, at least India, looks forward for equalization. So some method will have to be brought about, some policy will have to be evolved, maybe by taxations, by delivery of welfare goods, products. So please construe 39B and C as broadly, as widely as the framers of the Constitution envisaged. And my humble plea to your Lordship is, in this domain, since economic justice is a flexible phenomena, please do not draw a line. Except that line which ineluctably, necessarily, compulsively flows from 39B. With this, if your Lordship looks at, see how 38 to how broad it is. Eliminate inequality in status, facilities, and opportunities. Some methodologies are prescribed, Article 14, 15, etc. There is a continuous conflict between equality in fact and equality, which is called formal equality. This conflict will go on. It's a continuous phenomena, unceasing, requiring constant, continuous attention at attenuating or eliminating it. That's the message of preamble, that's the message of 38, and that's the message implicit in 39B and C. So keeping this in mind, my lord, please construe 39B. Let's look at it independently. There was one contention, my lord, that this talks of distribution, not acquisition. Acquisition stands before you distribute, you have to acquire. One more aspect may be kept in view, my lord, is it is not that but for 39B and C and 31C, acquisition is impossible. Acquisition under eminent domain, under the Land Acquisition Act, etc., can be done for public purpose. Even private property, even the hut plot which comes in the way of making the road plot can be acquired and compensated for. So private property is not beyond acquisition at all, even in the general law. All that this provision is now doing is, the lordships are scrutinizing, is whether protection of Article 14, 19 should be allowed to be taken away or not. Not that private property cannot be acquired. But once you declare 31C, it will not be there. So once 31C declaration is there in the Act, and it has nexus to 39B and C, then 1419 is shut out. That's all that happens here. And it is this limited domain which we are scrutinizing. So acquisition of private property is not sacrosanct, nor is it something which stands away from the domain of 39B. Now 39B, there cannot be a distribution to subserve common good unless acquisition happens. So acquisition of private property ownership and control. So some private person's ownership has to be taken over in order to be distributed. And that in which the state, which organs of the state, including parliament and state legislatures, have to move. There was some debate that in Article 38, the word strive should be deleted and substituted by some lighter word. Dr. Ambedkar said that this word has been deliberately brought in so to compel them to move in this direction. The most important goal for any parliament or legislature is to move towards equalization. It's unfortunate that inequality is still growing, and that's something to be tackled. That's the constitutional mandate. But 39B in the context of Article 31C involves a inclusion of declaration. So when 31C comes in along with 39B, then it's a source of power to make a declaration. Your lordships are called upon to look at 39B in the context of 31C. And 31C if it has to be invoked.
Not require a declaration.
No, it
That's-
doesn't talk of declaration.
That latter part brought in a declaration. That
struck
if there
out.
is a declaration, you will not review
That's
the
As
question.
the learned Solicitor General said that even if you don't have a declaration, still court can see. But if the legislature expressly says so, then your lordship will see the nexus. Once the nexus is established,
Then the conditions for 31C arise.
so in order to bring in 31C, the legislation must speak. I may not call it declaration, it must speak expressly. That because 14 and 19 are being shut out, so it must speak expressly or by necessary implication. So this is a power which is emanating from 31C. So when 31C comes into the picture, then this power and duty to speak about the invocation of 31C to shut out inquiry based on 14 and 19, for enforcing and implementing 39B assumes the shape of a power, which of course would be connected with 245, 246. And in that context,
31C is not a power, it's a limitation on legislative power.
but in as much as
immunity to legislative.
in as much as it is
It's
to
an
be,
immunity to legislative.
The-
It's not a limitation, but it in fact is an immunity.
the
challenge.
effect of invocation is immunity.
Right.
The effect of invocation is immunity, but the power to invoke, but for 31C, my lord, this can't be shut out. So the legislature must invoke 31C. (245), 246 by itself would not enable shutting out 1419. That is subject to 14 and 19. It is 31C alone.
There
Which-
must be a law giving effect to the policy
That's right.
of the state towards securing Article
That's right.
39.
So state will have to speak expressly or by necessary implication that it is to secure, the law is
Yes.
being made to secure this. In which event, 1419, then the court will only examine nexus, the reasonable and direct nexus. So therefore, coming back, 39B, when it says ownership and control, it was rightly submitted that the word and has to be read as and stroke or. And this is not unusual. My lord, the Chief Justice, my lord, and the other learned judges have in Jindal Steel, in the context of Article 301, read it in that manner. If your lordship has not, I have two volumes, volume 2H and 2N. Kindly have paragraph 20 of 2H, volume 2H.
What page?
Page 8.
Para 20.
Yes. I have quoted for convenience para 75 of Chief Justice Thakur's judgment. If your lordship will come down 10 lines from the bottom of that paragraph. The word and can mean or as well as and, depending upon the context in which the law enacted by the legislature uses the same. Suffice it to say that levy of taxes do not constitute a restriction, then that goes on a different. Kindly have, my lord, the Chief Justice Chandrachud's judgment. The word and is normally at the bottom of the same page. The word and is normally used in the conjunctive sense. However, this is not always the case. Coupled with the use of the expression may, the expression and in 304 should be construed to mean and stroke or. In other words, the legislature of a state may take recourse to both or either of them. So I would say, well, this happens when a power is conferred, then it's not essential that the entirety of the power be exercised. It's from this that this idea is flowing, as my lord the Chief Justice has put it very clearly. And then in the next paragraph 653, both and or are inherently ambiguous and is always conjunctive in the sense that it always signals and cumulative of the possibilities listed before and after the and. However, and is ambiguous in that it may be joint or joint and several. In the case of a joint and, every listed possibility must be included, both A and B, all of A, B, C. In the case of a joint and several, and all the possibilities may be but need not be included, A or B or both, A or B or C, or any two or all three. In other words, the joint and several and is equivalent to and stroke or. For the other learned judges, I have mentioned the paragraphs at the end. So in fact, as the Solicitor General, the learned Solicitor General said, submitted, and in this context of 39B, ownership and control should be both and or leaving it to Parliament, either to take control, either to take acquire, or to do both. So whichever subserves the good, that's the guiding star, and for Parliament to do. Take note of it. And it is not that acquisition has to be done first and then something else, step one, step two. It's all common there in 39B. If they are together, every law of acquisition need not stand alone. Nowadays, not all laws, as Your Lordship, my Lord the Chief said in the earlier cases, drag back. You can have one law, acquire and distribute. You don't have to have a separate enactment. And to separate it, acquisition from distribution in the context of 39B frustrates the whole purpose of 39B. Because the idea is to equalize, take from some and distribute. The second expression is distributed. How do we look at distributed? And I would submit with respects that the word distributed should be construed as a part of the entire phrase in which it occurs. So distributed as best to subserve. So distribution will not mean in every case distribute by bits and pieces, piecemeal, by metes and bounds. It may be in case of land where zamindari abolition, you take the land and distribute it to a large number of people. But in another case, let's say of spectrum, which is undisputedly a property of the community, a resource of the community. Now, this spectrum is not to be distributed by bits and pieces to the people in the country. There would be an auction or a tender, and somebody will get a lease or a license, and then he will set up the whole structure based on which the community will then be benefited. So that's another way of distribution of the benefit of the resource to the entirety of the community. So therefore, distributed will not mean always distribution in bits and pieces. And that's why it is part of the phrase, so distributed as best to subserve. There can be a large pond, for in Bengal, where we are standing, there are non-agricultural property, which is one of them is pond. And there are huge ponds, 500 acres of pond, or even more. So now water can't be distributed, because we set by concrete, divide it, and small portions given to a large number of people. So what can be done is that you take it over and give it to some cooperative society of a large number of people living around, and then they can utilize this pond. And there's another fear that the pond is not this, the private owner may feel that it's my property, so I'll fill up the pond. And we'll have a huge skyscraper there and earn money out of it. So these are choices which are restricted. As the Lordship said, that private property, my Lord the Chief Justice said that private property, there are certain private properties which inherently provide sustenance, or they are in the interest of community is inbuilt in that private property. There are private forests, there are wetlands. Now, this word distributed has been well, for construction, Your Lordship may note para 92 of Kabur Bhai's judgment, volume 5, page 238. 2348 it begins, and the relevant portion at page 2381. Para 92. In 91 and 92. Other dictionaries are also mentioned earlier paragraphs. May I place para 92?
Right?
Yes, 1984, 1 SCC. 515. May I place it? It is obvious, therefore, that in view of the vast range of transactions contemplated by the word distribution, as mentioned in the dictionaries referred to above, it will not be correct to construe the word distribution in a purely literal sense so as to mean only division of a particular kind or to particular persons. The words apportionment, allotment, allocation, classification clearly fall within the broad sweep of the word distribution. So construed, the word distribution as used in 39B will include various facets, aspects, methods, and terminology of a broad-based concept of distribution. In other words, the word distribution does not merely mean that property of one should be taken over and distributed to others, like land reforms, where the land from the big landlords are taken away and given to landless laborers, or for that matter, the various urban and rural sealing acts. That is only one of the modes of distribution, but not the only mode. In the instant case, as we have already pointed out, distribution is undoubtedly there, though in a different shape. So far as the operators are concerned, they were mainly motivated by making huge profits and were most reluctant to go to villages or places where the passenger traffic is low or track is difficult. This naturally caused serious inconvenience to the poor members of the community who were denied the facility of visiting the towns or other areas in transport. By nationalizing the transport, as also the units of the vehicle would be available to go to the farthest corner of the state and penetrate as deep as possible and would provide quicker and more efficacious facilities. This would undoubtedly be a distribution for the common good of the people and would be covered by 39B. So therefore, there will be various shapes brought in which this distribution can happen. Now the third expression, the next expression which in 39B is material resources of the community. So there are two parts. One is, my lord, to look at material resource and then material resource of the community. So as the lordships have laid down in various judgments, my lord, that one of the modes of construing is to dissect, break up the components, but not to stop there, but to reassemble them and then look at it as a whole. So dissect, separate, construe, and then see how the meaning fits in the as a whole in the context. So material resource, the resource, all resources which produce an income, they are a resource. As literally interpreted, contextually interpreted, and the interpretation has to be wide, except that which is non-productive of benefit, service, income, and is essential for living. For one has to remember that Article 21 is not part of it. For we have to remember that Article 21 is not part of this protection. So the right to shelter, right to livelihood has been held to be there in Article 21. So therefore, that private property, which is not productive, which is not a resource, but is purely for personal benefit, is not covered here. Otherwise, all other private property should be held to be within its ambit in its widest plenitude. And it should be left to Parliament to decide which one to touch or not to touch.
Whether it is tangible or intangible.
Tangible, intangible, all kinds of property. We don't know what will be the scenario. That's the problem a lot today. We cannot prognosticate what technology, artificial intelligence is now coming in. Robotics is now coming in. So what all will your lordship visualize in laying down a line? We will be back in the court again.
So you mean we should not?
Yeah, I'm saying that your lordship should not leave it to the Parliament. This kind of private property which I'm talking about, this property, no Parliament is going to touch.
The others also, they can acquire the property. Why not?
Sorry, Raj?
They can acquire also the property for distribution.
Yes, of course. The point is, in certain cases, the Parliament feels that Article 14 and why did 31A, 31B, C come, my lords? Because in the very beginning in 1951, the Constituent Assembly was acting as a Parliament, and it felt that 31A and B have to be brought in. Because, my lords, the laws of this land reform laws were being struck down by courts on the anvil of Article 14 and 19(1)(f) and so on. So it felt that on the one hand, we are compelled to have these measures to equalize, to uplift the downtrodden. And on the other hand, there is an interpretative exercise in the courts which is coming in the way. So therefore, they wanted to shut it out. So it happened right in the beginning, 31A, 31B. And your lordships have said, look, that in Keshwanand, that 31C is nothing but an extension of 31A. So yes, my lords are absolutely right that acquisition can happen. That's how I started, that acquisition of all kind of property can happen. Even the poor man's hut can be acquired if a road or a canal or dam or a metro is to pass. But there they have to pay compensation, market value, and all those concepts come in. And that was one of the basis for striking down of various laws, that the compensation are not being provided to the zamindars. So therefore, the Parliament wanted to avoid it, and they brought in the constitutional amendments to ensure that these questions do not become an obstacle and the country marches ahead. The agrarian reform, my lord, was a objective set before in the freedom struggle itself. And Article 51A says that it's the duty of every citizen to cherish the noble ideals of freedom struggle.
Lahore Resolution.
Yes, in Lahore Resolution 1929, as early as that, Pandit Jawaharlal Nehru was the president, and he was the pioneer of this agrarian reform. So agrarian reform, even before on the anvil, when we were on the anvil of independence, it was put forward and coupled, please see, I'm grateful to my Lord Justice Dhulia, because 1929 is the Lahore Resolution, 1931 is the Fundamental Rights Resolution of Karachi. So fundamental rights and the directive principles all were emerging simultaneously as a cherished noble ideal. So
29 is Swaraj.
that's the blend, that's the balance which Chief Justice Y.V. Chandrachud talked of in the Minerva Mills. They said the two wheels of the same chariot. And balance is the basic structure. That's the most important statement. Balance between the two is the basic structure. And sometimes this balance in some situations demands that some fundamental right be kept aside and not become an obstruction in the forward march, the further development or the upliftment of the downtrodden, the Dalits. So therefore,
31C itself is in the fundamental rights chapter.
that's right. And it's this part of the same scheme is as fundamental now. Read 39B, when in the context of 31C, virtually takes the shape of a fundamental right. It is actually a fundamental right because some people should not enjoy fundamental rights. By equalization, we take the fundamental rights and make them live real for the poor people. So that is to be realized. Everybody must enjoy the fundamental rights. So education must go down. Economics must ensure that the fruits are going to the people and to those who are laboring. So I submit, Lord, the only word now remains is community.
No, about this material resources. So should we assume that you are not making any distinction between property and material resources? You think they are the same?
All property, yes, but everything is property today, Lord. The concept of property started emanating when Lord John Locke started defining it in the context of occupation of America.
That means that may be, suppose somebody here discovers a cure for cancer today, right? That's his property in a way.
Yes.
That also become a material resource?
UPR.
It is intellectual property, Lord.
No, but intellectual property, there is some privacy attached to it. There
No,
are a whole lot of things.
I'm not denying.
What we are saying is, once you include tangible, intangible, everything is material resources, then that has to be decided, isn't it? Because this reference is for that only.
Yes.
This reference is for that only, that
Absolutely.
whether private property constitute material resources or not.
Yes.
So a distinction has to be made, or whatever, this has to be touched upon.
Let me put it like this, Lord. When we talk of an idea becoming a patent and therefore a right of that individual, that idea itself is a is a social product. My idea taking shape in my mind is not sitting in a jungle that I have formed that idea. The society has contributed in my upbringing and growth, and therefore that idea just bear me, I mean, I may be completely off track, but just kindly consider.
We are with you on that.
So now what happens? Now an idea is taken, somebody gets a patent of a cancer treatment. Now he says it's my property, I'm not going to aid the society in cure. Or that I will set up a hospital and then I will have such a high charge for it that people are not benefiting. Now, is the parliament then incapable of saying that it may be your property, but the country needs it? People are dying. So we make a law, therefore. So there can be a variety. All I'm saying is leave it to the parliament. How will your lordship draw a line that this particular idea, this particular property should be out, this should be in? That's a very cumbersome exercise. An impossible exercise, I would say.
No, that's a good, I mean, We will be. I'm willing to accept that idea that, you see, then there is no nothing like an intellectual property.
No,
Because before it becomes an intellectual property, it is in the nature.
yes,
It is in the nature before it becomes your property.
that is so.
So if that is so, then you are, that idea may not be acceptable to everyone, you see.
No,
You will accept.
if it's accepted to 9 of your lordships, I'm satisfied, my lords. I'm not concerned with everyone standing outside the court. Surely, as my lord, the Chief Justice said, there are Gandhians, there are Marxists, there are socialists, there are Fabian socialists, and so on. So each looks at the developments in its own way, my lords. My lords are absolutely right. Many may not. But here we are concerned with this, which the framers have made. And Constitution is a document, my lord, where every two persons will have a different view of it. That's the beauty of the interpretation exercise in the context of Constitution. There's no one. But which is more beneficial, my lord, where should, drawing a line, keeping out, how will you do it? Is entering into a boggy ground, my lords.
But assuming that material resources would include all kinds of property except those which are earmarked for personal use, as you said. But what about the words of the community?
Yes.
Does that interpose some sort of limitation
lords,
on what can be regarded as a part of that phrase?
Yes, I was coming straight to that only, my lords.
Community, and what should we understand as community?
Sorry, my lord? Community.
How do we understand community?
Material resource.
Community also.
Community, yeah.
The community does not necessarily mean the entirety of the population of the country or the state. Community would also be relative to the resource.
Yes.
So now let's look at it this way. Community, literally speaking, means a combination of it. Even two persons will be a community. In America, there is a Community Property Act, which deals with spousal property, which provides that all the property of the husband and wife together, whoever has whatever income, it will be shared equally. Its title is Community Property Act. So property earned by two persons will be a community. A firm, unless now, of course, we have a one-man company. So two persons in a firm, community.
In that sense. Like I'm sure you are aware of that. In UP, there is a law that in the pond, in the pond, the local villages, the fishing rights, the first charge is about the fishing community. So the fishing community will be given those rights first. So in that sense, for the fishing, the community will be only fishing community to get those resources. But for a larger thing, the entire country may be the community.
Maybe.
It depends upon the context.
Yes, of course. Maybe different spectrum. Whole country owns the spectrum. Everybody must get the benefit of the spectrum, use of spectrum.
So the community has to be seen in the context. In the context.
That's why it is relative. It is relative to the resource.
Yes.
Relative to the resource.
How broad the section of community will be benefited will depend upon the particular resource.
Yes, that's it. What did you say?
But resource it is.
What did you say just now?
How broad a section of the country will get the benefit of a particular resource would depend upon the nature of the resource. And where it is located. The very locale will restrict. If it is in Bengal, surely the fishermen of other states would not be traveling there, can't be given the benefit. It has to be, and the resource is also limited, not the locale alone, but even the size of the resource. But ultimately, if we go strictly by private property concept, as my learned friends want, then the pond belongs to a private person. He will say, why? It's my property.
Or if you have a mining lease, I say, well, it's
my property. No, actually, nobody was born with land and ponds and rivers and sources, but ultimately, this is the private property is a concept of law and is a concept of material development of the society.
And even if it is strictly private property, like say a lease creates an interest in land.
Yes.
It's a lease for mining purposes. Nonetheless, we've always accepted that there may be a regulation in the interests of the wider community.
Yes.
Because there is a community interest in regulating even private property. So for instance, in the case of mining, that there should be sustainable mining, that you should not completely depredate the earth of its mineral resources.
Yes.
And therefore, the very notion of community interest postulates that there is, even in relation to property of a private nature, an interest of the community in proper regulation. This is in the interest of proper distribution, so as to subserve, that the ownership and control subserves the common good.
And it goes to the credit of Parliament. In the last 75 years, how many times this has been invoked? Even the Mines and Mineral Act, 1957, your Lordship saw in that other matter, doesn't have this declaration, 31C.
No, but that is because of, first it was curtailed by Keshwanand Bharati and then by Minerva.
No, I'm not on that. I'm saying that we must give credit to the Parliament that it is not using 31C, blindly right, left, center, everywhere. Even in mines and minerals, since my Lord the Chief Justice gave that example, therefore I'm pointing out that in the previous exercise. Yes.
You gave. Distributed as best to subserve the common good. Now, when you subserve the common good in a given situation, you may be serving various common goods or benefiting various needs of the society.
Absolutely. For example, in the pond itself,
This pond example,
fishing is one aspect. All the cattle of that, they come to drink water in the ponds. That's another interest. People come to the ponds to take bath there. So
you can't be forgetting the buffaloes who wallow in this water.
yes. So when they are wallowing in them, there's little difference between the humans and the buffaloes. They all wallow together. In the villages, I've worked for 4 years with the downtrodden, so I've seen that phenomena. Where on the one side the buffaloes are in it, and on the other side the human beings are also. The ponds are very, very important for the village community. The only thing is that individual interest up to a point is to be protected, but there can be points raised where the society, the Parliament feels compelled that no, we have to do something with it. And we don't want to get embroiled in this long drawn litigation. So kindly see it, after 20 years, these litigations are coming before your lordships. और कुछ है नहीं। respectful submission means the people. They may also be individual people. They may be couple. They may be more than two. Communities cannot be limited to state. There is no color of state ownership there. It cannot be that Air India, my lord, when it was owned by the state, it was a material resource. The moment Tata takes over, it ceases to be material resource. Now that will be, there's another reason.
Engagement between people, because
Yes.
people become a community when you engage with them.
So today there's so much.
Maybe it's an engagement on just social interaction, professional interaction, religious interaction,
Or even economic.
or economic interaction.
Yes.
Some engagement between human beings is implicit in the concept of community.
Now let's
There has to be some element of an interest of the community in order to make it a material resource of the community.
no difficulty in all these things. The only problem will be at what point of time the interest will emerge.
That's a matter to be decided according
So
to
that's right.
context.
So therefore, my lord,
You can't
for us
attempt
to
an
draw a
exhaustive-
line, all I'm
an
endeavoring.
exhaustive definition.
My lord, right. So if my endeavor is limited to this, that it's very difficult in judicial review here, my lord, today to draw a line, my lord. That line may be crossed very soon. Such is the life, my lord. So it will present another problem. The best is to entrust and then see, my lord, where is it going? Is it going so far as to touch somebody's personal belongings, my lord? In that sense, which is not a resource, which can never be distributed for common good. So nobody can take my spectacle and say it is can be distributed, or everybody can't wear it, or everybody has a different eyesight problem. So it can't be distributed for common good. Yeah, personal effects. A better way to put it is the personal effects. So community, in my view, Millards, is just people in their engagement, particularly economic engagements. And common good, of course, is again relevant. As I said, does the acquisition and distribution which is contemplated, is it serving the common good? But that will be sitting again in judgment, Lord, as can't be a subject matter of judicial review. Lord, all that is therefore covered by the word nexus. Direct and reasonable nexus is for that purpose, which the court will see in judicial review.
No, but to see that nexus, we'll have to see whether it is for the community, whether it is a material resource or not. That much has to be seen.
If the Lordship accepts my submission that community is very wide and therefore, then of course there is little to be determined. Now, one more aspect is there, Lord. Today, a question is whether private companies, Lord, should be covered. Lord, what is a private corporation today? Even if every corporate promoter is today operating on the strength of depositors' money, which through the intermediary of banks, financial institution, is then given to them in loan and is utilized. A social interest, a community interest is directly there. If the corporation doesn't pay back the loans in time, the depositor's interest gets directly affected immediately. Then no production can happen in the manufactory of the corporation unless the labor power collaborates with the capital. And this is not Marxism. I am not afraid of Marxism. Our constitution, as Dr. Ambedkar said, we don't know which government will come tomorrow. It may be inclined to socialism, it may not be. That's what Dr. Ambedkar says. You also read it. So leave it to them. We cannot say today that if tomorrow a government comes which is inclined towards socialism, then there will be an obstruction. You can't move towards that. That can't be the mandate from the court. So flexibility. Our constitution makers have kept it pragmatic, flexible. It's up to the people to choose the kind of government they want, the kind of growth they want, and therefore, it is neither Gandhian nor Marxist nor Fabian socialist. Notwithstanding that the preamble has been amended to include the word socialist. There will be a great debate, my lord, if one goes, what is this socialist? There are n number of kinds of socialists in the world. All kinds of socialists.
No, but it is there in Article 43, capital A.
Yes.
43, capital A is just what you're saying.
Yes, the state shall take steps by suitable legislation to secure the participation of workers in the management
And read further.
of undertaking establishments or other organizations engaged in any industry. So every corporation engaged in rendering service, trade, commerce, it's a community. Not only this, the shareholders are there. A body of shareholders contribute. There are debenture holders, bond holders. There are private money lenders. So there's no way, my lord, that this private corporation today can claim to be private in the sense at one point of time we enclosed a piece of land and said that it is mine, excluding the other. And closing the property and excluding others, which is the primeval form of private property, that doesn't exist. It is collaborative exercise today. Every private corporation, even if it is a one-man corporation, it will be borrowing money. It will be using laborers. And all those liabilities are there. And to top it all, they produce and manufacture for the consumers, which is a continuous exercise. Without the consumers, there will be no maximization of return, no profiting. They are seeking profits, and profits are coming from our pockets.
From there, the taxes are going down.
And taxes.
That is used for social welfare only.
And tax, government takes the tax, and when these corporations are in crisis, they go to the government, and government then supports them. So where is, just look at it, this whole phenomena of industry and business today is a community exercise, nothing else.
OTS also.
Sorry, Mulas?
OTS also in the banking.
Everything, Mulas, nothing. That's why I'm saying, Mulas, that how do we define? So many imponderables are there, so much flexibilities are there. See, these words, if you're watching, it's really impossible.
This now
This
covers
completes
part
this
now.
part of it, Mulas, except that if Lordship may just note at page 20, para 26 at page 12 of the note. I have extracted some portions from Justice Khanna, Justice Y.B. Chandrachud, as the Lordship then was,
In Keshwanand, right?
from Keshwanand, to where they say that 31C is an extension of the principles of 31A. The relevant lines, I have made it bold, but I have extracted the whole paragraph. And the other learned judges, I have given the paragraph at page 16. Paragraph 30, page 17.
What else, Mr.
Now, leaving this topic, Lords, the other note, Lord, which he gave subsequently because the Lordships heard on the issue of survival of 31C.
We are on 31C now.
Yeah.
How much of it survives?
Not
And-
how much,
and-
Lord,
and
unamended.
its effect, it's
unamended. And my submission is the entirety of 31C survives, Lords.
Your note is 2H.
2N.
2N.
2H was the one which I was reading.
Yes.
This is 2N, which has something of
Right.
39B also, but
Now on 31C, what is your point, Mr. Bedi?
not the first point on 31.
We will be rising today at 3:30. I have to address a conference in Tajikistan, actually, as part of the Chief Justice of India's responsibilities. So about 3:30, if you can rise. So in 20 minutes, will you be able to wrap up on 31C?
It won't finish, Lords.
How long would you take on 31C roughly?
I think my lords, I'll take about an hour now on this.
Then Mr. Shankarnarayan? And nobody else, right? Just Mr.
I think Mr. Shyam Devan is to, and Ms. Aishwarya.
All right. So tomorrow, of course, we'll go on till 3:30, 3:35 right now. But tomorrow, if Mr. Dwivedi, can you wrap up, say, in about 45 minutes tomorrow by 11:50?
I can, whatever.
So
Is your lordship's
only
command.
then what we can do is that we'll give the others, Mr. Shankarnarayan, about 20 minutes. How long would you take?
I think a little longer than that. I have 11 points to make. Those are the 11 points which are covered by my 2 notes. But it requires a little bit of reading. There's some aspects have not been touched on.
So long as all of you can complete by, say, 12 o'clock tomorrow, and then we'll give them 1 hour for the rejoinder. 1 rejoinder, 1 hour, then we'll wrap up. We'll complete at 1 o'clock tomorrow. We'll finish with lunch. I think that'll be okay, no?
And for Minerva. Can I just indicate my...
For them for rejoinder, so that then we can have 1 rejoinder from them.
Can I just indicate my volume numbers are 2E and 2F and for Minerva.
All right.
So I've the initial pages that are as a lot of voluminous, but my note itself has links to the annex. So the initial note is 4 pages, the second note is 2 pages. It covers everything in that.
1C.
Yes.
What happens to 31C post
Yes.
Minerva?
And the learned solicitor has submitted that Vaman Rao and
There are 2 young men who also wanted to address for a few minutes each.
No difficulty, but this side we'll have to conclude by 12, so that by 1 o'clock we conclude tomorrow. So between all of you, just talk to Mr. Diwan in the evening, so that, between all of you, you lay down a schedule. So that 12 sharp we'll conclude this side, so that 1 o'clock we can conclude the hearing. I think that will be fair for everybody. 1 hour.
I'll be taking 15.
No difficulty. 12 o'clock for this side and 1 o'clock for this side. All of you sit down together. 1 rejoinder. Any one person can make the rejoinder. We'll have 1 rejoinder. Because we follow in CBs, in constitution benches, we follow 1 rejoinder because. You want to make the rejoinder, we have no difficulty. Talk to all of you settle who will make the rejoinder.
Article 25?
25.
Article, which
25.
article?
If it remains in Article 25, what is the purpose?
20.
Who's
25?
dealing, we're not dealing with
We're
Article
not dealing
25.
with 25. This is the first time we heard 25 in the last 5 days. Just a question of 60 differences, so 6 and 3, 9 actually. All right, yes, Mr. Dwivedi.
Well, so far as the interrelation between Minerva Mill and Vaman Rao, the learned solicitor general has made the submission, which I stand by that note and I adopt that part of it. Namely, that the 2 orders were passed on the same day. Dissenting judgment is common.
So 2 orders passed on the same day.
Dissenting judgment is common. And 2 learned judges, the learned Chief Justice and Justice Bhagwati, are common to the bench. They take note of the observations made in the judgments. So both judgments have to be read together. And in view of that, the unamended 31C should be considered as alive and operative. Now, let me assume, my lord, that in Vaman Rao's case, since they were dealing with an enactment which is pre-Keshwanand Bharati, and therefore they were not really alive to this question, I'm assuming, that therefore these two judgments don't conclude. And we have to see then the effect of the declaration in Minerva Mill. I will not read para 75, your lordships have seen what is declared null and void and beyond Article 368 is Section 4. Which for convenience I've extracted at page 5 of this second note, 2N. Yes.
M.
N.
Yes.
N Panakat. Look, please, my first submission is, please draw a distinction between a declaration which says that the amendment is void. That is, the substituted provision is void. And a declaration which says that the provision which is substituting is void. I hope I'm clear. The substituted provision is void, and the other is that Section 4, which is trying to substitute itself, is void.
Aren't they the same? The provision which is sought to be substituted, ultimately it becomes the substituted provision.
That's the effect of Section 4. But Section 4 as a whole has been declared to be void beyond Article 368.
Examination was only to the amended provision.
Amended, whether it has.
No, look at the declaration.
No, final declaration maybe, but examination was only to the amended provision.
It had to be because the court was saying that unamended was narrow, amended is very broad, virtually brings in all the laws which can be contemplated, barring some few, and therefore the expansion, the enlargement is void and beyond the scope.
31B also this court says.
But we have to give effect to the declaration. Reasoning, my lord, is to understand how they reached the conclusion. The reasoning will not decide, my lord, the scope of or the effect of the declaration. For that, we have to see just the declaration and the effect, not how they reach that end. So the end point is not that this expression, all the provisions of Part 4 are struck down. There can be two. The court could have said.
Article 368 is really the amending power. And Article 368 as interpreted contains limitations on the amending power. So the declaration which our court issued was that the limitations on the amending power had been transgressed by bringing about Section 4. And therefore it was null and void.
Yes.
So therefore you are making a distinction between the substituted provision and the very process of substitution. The process of substitution was held to be ultra vires Article 368.
The whole process has been found to be faulty, beyond the constituent competence.
So if the process was found to be faulty, then the net consequence is that it did not result in a valid exercise of constitutional power, inserting it into the Constitution.
I'm grateful, sir. That's precisely not what I wanted to respectfully submit, that this doctrine of basic structure in Keshwan and Bharti, it was propounded as a limitation on the constituent power in 368. And this limitation is unlike a limitation on the lawmaking power which is provided for in Part 3 or in some other constitution provision of the Constitution. there are various provisions in the Constitution which in different contexts provide limitations. For example, 286, which was grappled in Sundararamayya, to which I will advert presently. So the consequences with regard to them is different. In 368 is a constituent power. If your lordship just see 368(1) itself, your lordship has seen that 368(1) says notwithstanding anything in this Constitution, Parliament may, in exercise of the constituent power, amend by way of addition, variation, or repeal any provision of this Constitution in accordance with the procedure laid down in this article. Now, that procedure, necessarily we have to read Keshavanand Bharati's dictum, which means you cannot amend the basic structure, except the basic structure.
It's not so much a matter of procedure as of substance also.
Yes, or procedure is the special majority or ratification, in certain cases in proviso. So this is, you cannot do this. There are certain parts of the Constitution which cannot be destroyed.
But is there a distinction between an act being found unconstitutional, say, it may be found unconstitutional on the ground that it is lacking in legislative competence? An act may be found unconstitutional on the ground that it is contrary to a provision of the fundamental rights. Third, on the ground that it violates a substantive constitutional provision like Article 286. And fourth, that it is in violation of the constituent power. The 368 procedure is the recourse to the amending power has been held to be null and void here.
So if, for the moment,
is there a distinction in this area that we are looking at, depending on what is the ground for unconstitutionality?
Yes, I will advert to that, notes. But before that, let me dwell a little more on 368. If a procedure is not followed, for example, if it is not passed by 2/3 in its project,
or you don't have ratification,
or something requires ratification, like, and you don't have the ratification, then it doesn't result in a constitutional amendment. It is as if it never happened, which means the Constitution never stood amended. This last expression,
right.
Thereupon the Constitution shall stand amended.
Says can be applied at a time.
Yes.
It's a very crucial expression, the word.
Violating a constitutional provision, it cannot be brought back again.
So, for instance, if you did not have a 2/3 majority and the constitutional amendment, it fails for that reason, you can still bring in the same constitutional amendment.
We can bring in,
Yes.
we can.
But if it is violative of fundamental right, you can't bring that
it
again.
also back. That's the distinction between the two. But in one case, it doesn't stand amended. Equally, in the other case, it doesn't stand amended because basic structure cannot be amended. Please, therefore, this Keshavanand's dictum is very, very important. It has to be read into 368.
So where an amendment is found to be violative of the basic structure, is it your contention, therefore, it is as if the amendment never entered into the Constitution?
Never entered into the Constitution. That's what.
What happens if an amendment is found to be violative of Article 14 or 19? There, does the amendment enter the Constitution, or it enters the Constitution but is declared to be void?
No, just allow me a little more breathing time to come to that. Fundamental rights, there are cases which my learned friends have also referred to, completely out of
nobody
context.
cited Ambedkar Mills, Justice Matthew's judgment.
I'll deal with all the cases with great respect to my learned friend, but they don't say what he wants to say. They don't say what he wants to say. It doesn't, they were entirely, most of them are in different contexts of Article 13(1). Balsara, Peshikaka, all these are on 13(1). Sundararamayya is breach of 286. They're not dealing with basic structure. It's very easy to attempt to transplant it from one soil to another soil, 368 context. But before that, one has to draw a parity. All these cases, but one streak is common. They all of them without exception say that if it is beyond the legislative competence, not 368, with respect to 7th schedule, they are null and void ab initio, ineffective, to be ignored. To be ignored.
Article 13(4) does not apply to a constitution amendment
Yes.
where it defines law.
Yes.
It does not include the constitution.
Except since your lordships have in Colo said that 14, 19, 21 form the basic structure. So it can be abridged but not destroyed. Yes.
Equating, in other words, something which is lacking in legislative competence with something which is a violation of Article 368.
I'm saying
The consequences were similar, namely that there was no valid entry into the Constitution itself.
it never entered. That's how it is to be treated. That's how the declaration in para 75 has to be read. The Constitution did not stand amended in terms of the bill. The very bill is knocked out. Just have a look at the procedure, my lords, for a second.
If it is violative of legislative competence, there can't be a validating act by that legislature. If something is struck down as being lacking in legislative competence of the state legislature, Parliament may pass a validating act, as it does in the case of tax. Maharashtra enacted a law, tax found to be unconstitutional. Parliament can enact a validating act. Can that be done in the case of a law which violates the basic structure? No. Likewise, therefore, if it violates the basic structure, there is no question of a validation of the law, unless you cure the defect on the basic structure. Right?
That's right.
But therefore, both of these cases, according to you, result in nullity at the point of birth of the...
Birth itself.
Or it's not born at all.
Not born at all. It goes to the bill. Please see the.
So what happens if a law violates a fundamental right? Is that law born into the Constitution?
There is a distinction between 13.1 and 13.2. In some cases, and the great jurist, eminent jurist, Mr. Sirwai, has tried to draw a distinction. He says that both are similar. The judgments are otherwise. He has criticized the judgments. But as the judgments stand, there is a distinction between 13.1 and 2 because 13.1 deals with existing law.
Right.
Yes.
So these laws, pre-constitution laws, they are made before. When made, they were valid. So they can't be knocked down from the inception. They continue by virtue of Article 372, subject to the provisions of Constitution.
Otherwise, the doctrine of eclipse.
Doctrine of eclipse.
Doctrine of eclipse to a pre-constitutional law.
That's right. And Mr. Sirwai says not that why should not doctrine of eclipse apply to 13.2 also. But that's a different debate which this court may have to resolve if required. And I don't agree with the esteemed jurist on that point. Take two for a second, minute. The procedure is somewhat different from the ordinary lawmaking. Procedure. An amendment of this constitution may be initiated because sub-article 1 says in accordance with the procedure laid down in this article you have to amend. Then 2 says an amendment of this constitution may be initiated only by the introduction of a bill for the purpose in either a house of the parliament. If I may pause here, no bill violating doctrine of basic structure can be presented at all. And when your lordship declares it violative of basic structure, then the bill itself goes. Where is the question of it turning into this act? There is no such thing as act. Procedural, as a matter of practice, it is said Constitutional Amendment Act so and so. It's actually and even let me read further. And when the bill is passed in each house by a majority of total membership of that house and by a majority of not less than 2/3 of the members of the house present and voting, it shall be presented to the president, who shall give his assent to the bill. And thereupon the Constitution shall stand amended in accordance with the terms of the bill. So the terms of the bill get incorporated. It is the bill which is knocked out by the declaration in para 75.
No, the bill gets transformed into an act after the president signs it.
If your lordship, absolutely right, but if your lordship declares that bill to be violating the doctrine of basic structure, then there was no bill. That's right. So to the extent section 4 is knocked out, that part of the bill goes.
Really, maybe rise today, there's some.
Yes, sir.
We'll continue tomorrow morning. We'll continue at 10:30 tomorrow morning. About 11:15, if you can wrap up, Mr. Dwivedi,
Yes,
then can,
11.
the others can continue for another 45 minutes. If Mr. Dwivedi is taking longer, then the others can, in that sense, cut down their arguments, so that between all of you sit down for, we're giving you 1.5 hours and then 1 hour. We take it that Mr. Andarjana, you'll be making the rejoinder now?
Discuss with my
All
colleagues.
right.